Good. Good morning, everyone. Welcome to the Joint Standing Committee on the Judiciary. We have 3 work sessions this morning. I'm going to let everybody know the order, and I'll announce it again after introductions in the event others join us. But we're going to start with 1941 and then 2150, and then we'll complete our morning's work with 1911. And so at this time, we'll have committee member introductions. And Representative Sinclair, would you like to begin?
Good morning. I'm David Sinclair, here for the people of the city of Bath, House District 50.
Good morning, everyone. I'm Dylan Pugh. I represent House District 114, which is part of Portland.
Good morning, everyone. My name is Rachel Henderson. I represent the people of House District 78, which are the beautiful towns of Bethel, Byron, Hanover, Milton, Roxbury, and my hometown of Rumford.
Good morning. I'm Danny O'Halloran, and I represent District 20, which is the industrious city of Brewer, or most of it.
Hi, Dave Hagan, Senate District 10, several towns surrounding Bangor and not Bangor.
Good morning and welcome, everyone. I'm Elizabeth Caruso. I represent House District 72, which is much of northern Somerset County.
Good morning. I am Mark Babin. I represent House District 3, Northeast Aroostook County.
Good morning. My name is Ellie Sato. I represent House District 109 in the beautiful town of Gorham.
Welcome. I'm Adam Lee. I represent House District 89, which is downtown and New Auburn.
Good morning. I'm Jennifer Poirier. I represent House District 70, which is Skowhegan.
Good morning. I'm Amy Kuhn. I represent House District 111 in the town of Falmouth, and I serve as the House Chair of the committee. Welcome.
Hello, everyone. My name is Ann Carney. I represent Senate District 29, which includes South Portland, Cape Elizabeth, and a little bit of Scarborough. And I serve as the Senate Chair of the committee. And it's nice to see everyone on this beautiful snowy morning. We're joined today by OPLA analyst Eli Murphy and committee clerk Susan Panett. And before we start our first bill, I'm just going to remind everybody of the order that we're following this morning. The first work session will be on 1941, which is the reestablishment of parole. The second will be 2150, which is procedures for restricting access to state property. And then 1911, which is sealing criminal history record information. And so with that, we'll open our first work session on LD 1941. And Eli, can you just orient us to where we are, please?
Sure. Eli Murphy, Office of Policy and Legal Analysis. When we last worked on this bill, there was a significant amount of discussion, and I think one of the hangups to voting the bill at that time was just a copy of the amendment that was cleaner and easier to read so that we could have a kind of concise conversation about what is in the bill, what is not in the bill. And so SUPI is currently passing out. The committee had requested a copy of the amendment that looked like a printed bill. It was just a strike and replace. And so everything that is contained in the amendment that SUPI is passing out to my understanding, are all the pieces that are requested to be in the bill based on Representative Lee's amendments to the bill as printed, removing the things that were both contemplated at first and then taken out, et cetera. And so we have a much cleaner copy to go on.
Thank you. And I would ask whether Eli, you, or if you wish to defer to Representative Lee, it would be nice to have just kind of a not super detailed walk us through the bill, just to refamiliarize us with it, given that the format has changed a lot since we've been working on it.
Sure. I would defer to Representative Lee if that's all right, just because some of this is the why of the changes, which is for him to say versus myself to say, if that's.
Representative Lee, do you mind if we put you on the spot?
I'll do the big highlights of the changes. Highlight number 1 was the addition of an executive director to manage, in particular, the creation of a set of guidelines. Big change number 2. I mean, I we're going to be going from different pages. I'm trying to give a high level rather than going line by line like I did last meeting. So the addition of the executive director, the change to a comprehensive risk and stability and suitability analysis rather than the previous one, which I felt was a little too proscriptive. And that's
on page 3 of the draft.
yeah, as well as other places because it changes the assessment that happens for things like probation or parole revocation hearings as well. The procedure, I whittled that down significantly. That's largely on page 5 and 6. Leaning on the Administrative Procedures Act rather than on a whole bunch of other particularized forms of procedure. I think most significant change, deciding on a policy of allowing it to be both prospective and retrospective, retroactive, either or. As to individuals who have been sentenced since 1976 and up to the enactment date or the effective date. And with respect to those individuals, a simple majority of the parole board is insufficient to grant parole. You need 5 out of 7 of the individuals on the parole board in order to grant parole. And then just sort of whittling down the factors more effectively to something that can be created for the assessment by the parole board. Those are the big highlights of the changes that we made.
Thank you very much. Does anybody have a question for either Eli or for Representative Lee? That's more granular than the highlights that we just heard about. I'm not seeing any questions. Is there? Yes, Eli.
And so just one thing I'll point out, and I know there's no questions, one thing I'll point out is really in substance, the amendment hasn't changed from the discussion last week where you kind of went line by line, very in detail. So you're nothing from your understanding then has really changed to this draft here, just the format it's presented.
Thank you.
That, and I think there are a few small technical things that came up over the course of that conversation that we wanted to fix.
Okay. Is there any question that any committee member has for persons in the committee room? Representative Kuhn?
Thank you. I would love to ask the bill sponsor a question.
Welcome.
Thank you. Good morning.
Good morning. I'm struggling with this bill a little bit because I really appreciate the importance of the policy and I'm getting hung up a little bit on implementation. And it seems to me that this would make a more comprehensive solution to this problem if sentencing was also addressed in the bill, because then you're not getting into these potential conflicting situations where there's probation revocation and parole revocation, and a judge wants someone to go back into custody, but the parole board says, no, they're not coming back into custody. And I just wondered, did you think about building out a more comprehensive bill that also would address needed changes in sentencing? I'm just wondering, like, why take just this one lane as opposed to the whole issue? That makes sense.
Thank you for the question. I'm not an attorney. Anita Milliken, sorry, bill sponsor. I'm not an attorney. I've spoken about the bill at length with many attorneys who seem to all have conflicting viewpoints on the issue of whether or not resentencing needs to be addressed. I think Representative Lee in your last work session on the bill kind of asked Attorney Burns, Shira Burns, why the issue she had presented before this committee around sentencing would be an issue at all. And also I've heard from Shira Burns, of course, that would be an issue. So as a person who's not an attorney, I don't know that I can speak specifically to that issue, especially when I have people who are attorneys who can't seem to agree, as I see it, on whether it's an issue that needs to be addressed. So no, I haven't, I guess, sussed through whether or not that's a necessary thing to move forward with, because I can't get a solid answer from people who would know better than I on whether or not it's an issue that needs to be addressed in the bill. Is that a fair answer? Okay.
Go ahead with your follow-up.
May I ask a follow-up of Representative Lee?
Yes.
Okay. So I recall that exchange and your answer was, well, I guess they'll have to talk to each other, or there would have to be some kind of coordination. Am I remembering that right? How did
I
you
didn't-
square those?
I didn't say that there needed to be coordination. I said there are all sorts of circumstances, and I think Representative Sinclair had a very good example with an OUI. You have the Board of Motor Vehicles who's proceeding at the same time as court, and that doesn't present significant hurdles. You have an administrative agency who's functioning on the same set of facts, but with different remedies as the courts are. And so that's parallel to what would happen if there was a probation revocation at the same time as a parole revocation. Oftentimes, those things can be concurrent and do run concurrently, even though you have two very different agencies functioning on very different sets of rules and circumstances.
Yes, Representative Kuhn.
Thank you. So I'm trying to understand the analogy to the administrative process. So what if you have a situation where there's a probation hearing, the judge wants the person to go back into custody for 2 years. There's a concurrent parole hearing. The parole board says, no, either you're fine, stay out on parole, or you know, come back for 6 months or something, and then we're going to reassess. How does that work if that's like a judge ordering one remedy that then the parole board is overriding or getting precedence over? Do you see what I mean?
Yeah. And that's why I think the OUI example is particularly useful. And I'll let Representative Sinclair, who deals with this far more frequently and more recently than I did, but in those instances, you have a suspension of someone's driver's license, right? One of the things that comes out of a sentencing in an OUI is also a license suspension. The judge accounts for what's happened in the BMV and is aware of what happens in the BMV because they're informed of it, and oftentimes runs those two sentences concurrently. And so it's not as if the right hand functions without being aware of the existence of the left hand. And I don't, that's why I just don't see that there's an issue. And I'll again defer to Representative Sinclair, because I think he'll probably be able to give a more eloquent answer to that.
Yes, Representative Kuhn.
Just one more thing and we can move on. I guess just in my mind, a license revocation is not the same thing as a return to custody order. I mean, those seem like different levels of severity. And I can move on. I'll consider what's been said. Thank you for that.
Representative Sinclair.
Thank you, Madam Chair. I just want to quickly observe, yes, they're different, but they're structurally identical in that in each domain, each of the two decision makers is acting within the scope that they are given. So sure, BMV can't send somebody to jail. Only a court can do that. They have the authority to impose a suspension, as Representative Lee correctly pointed out. The court, if it decides also to impose a suspension, they go concurrently. That exact same approach could work with respect to the scenario you're contemplating, where a parole board might make one decision, a court makes another. If they make the same decision, no harm, no foul, nobody cares. If one of them imposes a sanction that's more severe than the other thought appropriate, the person would go back for the amount of time that the more severe sanction required, and they would get credited concurrently in each of the two matters. So if the parole board thought the person only needed to come back for 3-4 months and the court thought 6-7 is more appropriate, they would go back for whatever the court imposed, and that would at the same time satisfy the sanction imposed by the parole board.
Yes, thank you. Did you have another question?
Just, can you show me where in the bill that priority is articulated or where elsewhere that's articulated? Because that, I just want to make sure that my that assertion is accurate. Because as I understand it, the judge would return them to the custody of the DOC, and then the DOC would follow its procedures under the parole board, in which case the parole board's decision would be prioritized. So I just want to make sure I'm understanding that. Yep.
The individual, either resident or defendant, depending on which context we're looking at them in, gets credit on a docket. Both the parole board and the court, they share a docket number. The number of days that the individual spends, they're getting credit against the sentence that was imposed for that docket. So it doesn't matter which of them imposes the longer sanction, because any day that they spend in custody, they're getting credited against that underlying sentence. Now, I can't point you to a specific place in the bill where it says the two sanctions will be per force concurrent. I also can't point you to exactly where in the BMV rules it says these sentences will be concurrent, but I can say that in practice, that's how it works.
Going to interrupt this dialogue for a minute and ask if we could hear from Jill O'Brien from the Department of Corrections, because I think we're confused. Well, actually, if you can join us, Jill O'Brien, and then I'll explain my question.
Good morning.
Good morning. Thank you for joining us. So we're using the term in custody as though it means being detained versus in custody being that the Department of Corrections has jurisdiction to impact someone. And it seems to me that like this conflict is not just a kind of an implementation glitch, but it's really a concern if they're both probation and parole are existing at the same time. It's a conflict over who has the right to determine whether that person is in custody of the DOC, is detained, et cetera. Am I mistaken about that, or is that a concern that you have about this legislation?
It is a concern. And I think, for example, when a court finds someone has violated probation, they may say, we command you to the custody of the Department of Corrections for 6 months. At that point, corrections would then follow 34A with respect to that person, which will include the parole bill. So I think corrections would be confused about whether the parole, assuming a parole proceeding had also just happened. Now that the judge has done its thing, do we now take the parole board's decision under 34A because the judge has given us custody and now our procedures apply? So I would recommend that it gets spelled out how the committee wants to handle those situations. There are always exceptions. There's something in statute in 17A called supervised release, often for sex offenses, that doesn't commit someone to the custody of the Department of Corrections. Oh, and Representative Sinclair is shaking his head. Maybe he should be the one to explain, but it says, thou shall serve time in prison, which is our facility, obviously, but it's worded differently, and we think that's intentional.
Do you have any thoughts about how to resolve that issue?
I really think that prosecutors and Shira would be the experts on that. The Department of Corrections, we fulfill sentences that courts hand down. As far as you'd certainly want to, and perhaps the courts have an opinion on it. I think it would be good to clarify if parole and probation, if one should happen first, particularly if parole is happening without attorneys. I think the attorneys in probation might have opinions on what records were shared in parole that may impact their proceeding that could potentially violate rights or due process. So that it's complicated, and I think an order should be established and considered.
Thank you. Committee members, any other questions for Jill O'Brien? Not seeing any. Thank you.
Thank you.
Committee members, is there anybody who has questions for anyone else? Senator Hagan?
Did we get a resolution to Representative Coon's question on where in the bill is this? I can't hear you.
What, Representative Lee, could you?
I said it's in the same place where it is in the OUI bill, which doesn't require that clarification. It's in the same place where these concerns aren't in the bill. If this is an issue, a genuine issue, it's interesting that it's surfaced now. I appreciated that it's surfaced now. If there's a suggestion for a language change, I'm fully amenable to hearing what that is from anybody.
I would just like to volunteer that I am the one who surfaced the issue because I very much want to vote for a prospective version of parole. But I don't want to vote for a bill that can't be implemented. And I think that the questions about priority of the parole board versus the judge's decision-making and who in whose custody is the individual who's seeking parole or is on parole and probation. I think that those are really real questions that I would want answered in order to vote for prospective parole. And I don't, I think they can be worked out actually, but I just don't know how to work them out. Any other questions or discussion, committee members? Any committee member wish to make a motion? Representative Lee.
I move ought to pass as amended, with the yellow version and with some grace, I hope we have an opportunity for myself, Eli, the individuals who are suggesting a change to the bill for that clarity can work on it in the process of coming back for language review.
Thank you. Is there a second to that motion? Seconded by Representative Sato. Any discussion, committee members? Yes, Representative Kuhn.
So for me, that clarification is very important, and I just wonder if we could not vote on the bill right now and wait until language comes back and have a chance. I know we've had a lot of work sessions on this bill, so there might not be appetite for that. But before I cast a vote on it, I would really like to see that addressed. I don't want to vote against the bill, but I genuinely have concerns about that. I'd like to see it worked out if it's possible to be worked out.
Representative Lee.
Do we have a deadline for the bills that we have permission to be working beyond the deadline that we're already working?
So, I mean, the ultimate deadline is April 15th, but we also, this is a bill that's been in our committee for, this is the second session it's been in our committee. There has been, the opportunity over the summer and fall to work on it. You've done tremendous work on it, Representative Lee, and I just want to highlight and thank you for that. Yeah, and I'm like Representative Kuhn, I'm kind of torn between I mean, we could continue to work on it for one more work session. The other option would be to vote on the bill and then leave it to, we don't know whether a resolution will be available. And so do we, look toward a floor amendment, for example, to resolve that conflict. Yes, Representative Lee.
I think my preferred course would be to vote it today. Try my hardest to work on that before language review comes back and perhaps do a reconsideration at the time it comes back for language review, which we usually do in the normal course, or barring that, maybe a floor amendment.
Can we have a straw poll of committee members who prefer to vote today? 1, 2, 3, 4, 5, 6, 7, 8. Oh, okay. So it looks like the majority of people vote today. I will be voting against it until we see the implementation issue be repaired. But with a heavy heart, because I really believe we need prospective parole. Anybody else like to be recognized? Yes, Representative Poirier.
Thank you, Madam Chair. I'll be very brief. As you mentioned, we've been working on parole bills for several sessions now. And one thing that really strikes me when we're even considering parole is the victims and their families. I'm voting against this, not because I don't particularly like the language or anything like that, but I'm putting the victims and their families first. I've had an opportunity to speak to victims' families who are absolutely horrified at the thought that they may at some point be forced to relive what's happened to them and their loved ones. So that's where I'm shooting from for this, and I'll be voting against the motion.
Any other committee member wish to share reflections? Representative Sinclair and then Senator Hagan.
I very much support the policy and think that parole is something that Maine needs and has needed for quite some time in order to join the rest of the country in recognizing that people can be redeemed, that everyone deserves an option, a chance, really, to show that they have performed, even while incarcerated, far beyond the expectations of the judge or justice who initially imposed the sentence. I'm voting against the motion for two reasons. First is the issue of retroactivity. When sentences are imposed not after trial, but as a result of a plea, that plea comes about through negotiation between attorneys for the state and attorneys for the defense. If we make this such that it can undermine those negotiations that happened previously, number one, I worry that it would send a message that some of the participants in the system haven't been participating in good faith, which I think would be a horrible thing to happen in our state bar. Number two, I'm concerned that it would cause negotiations that happen on a daily basis to become more strained than they are presently, given the uncertainty that would be injected into the process. So I don't support the policy applying retroactively. I also think that the bill should be explicit about the fact that the defendant / resident is entitled to state paid for counsel at the time when they have a parole revocation hearing, much like they do at a probation revocation hearing, because I don't believe we constitutionally can reimpose incarceration, even though they would be staying under DOC custody. I don't think we can constitutionally reimpose actual incarceration without affording counsel.
Thank you. Senator Hagan.
Thank you very much. I'm also concerned about the retroactive nature of these things, but I'm also very concerned, and have been since I was placed on this committee, with the victims and victims' rights. And yes, we should all have a second chance, but what about the victims? They don't get a second chance. And this to me is looking at parole for years and federally, statistically, state by state, and how these things go. I'm just concerned for the victims. What Representative Poirier talked about is having to go through all these things again. I don't care what it is, Class A felony down to a C or what have you. Victims don't have a second chance. They can't, they have no say. And if I'm willing to do something to harm another person, then there is a mechanism in place that has worked for decades in the state of Maine. And I am concerned that this will really cause way more problems down the road for those who didn't ask to be victims. They were made into victims. That's what I would say.
Anyone else like to share their thoughts or participate in discussion? Yes, Representative O'Halloran.
There's parts of this bill that I do like. But to me, there's just way too much of a gray area on the sentencing as far as it's not being clear, like we were just talking about, and that would, for me, also have to be ironed out. Victims obviously is another issue that I addressed earlier. And I also feel like currently that the DOC is doing a very solid job with the probation and things like that. And I do think that there are plenty of opportunities for people to show that there are improvements and to be recognized and to be given an opportunity currently with what we have. And that's all I have to say.
Thank you. Anything else? Yes, Representative Sato.
Thank you, Madam Chair. I will be supporting the motion because I think on a policy level, I believe that this is the direction that we should be going in trying to restore, actually implement more restorative justice practices into our criminal justice system. I just wanted to address quickly issues that have been brought up about victims' rights, because there is a section in the bill in subsection 5830 called victims' rights that actually allows.
Can you point us to a page number?
Sorry, page number 9.
Thank you.
Where there is an availability for persons affected to be able to testify or not testify before the parole board on a hearing about a case. So I just want to reaffirm that that is included in the bill. And I will also share that I think the sponsors work diligently with organizations that work predominantly with survivors of crime to ensure that these rights are enshrined in this bill. Thank you.
Thank you. Yes, Representative Poirier.
Thank you, Madam Chair. I just want to piggyback off of Representative Sato's sentiments. I appreciate what she's saying, but what I'm talking about when it comes to victims and having to relive things, it's not just being able to plead their case in front of a panel of people. It's the fear of, is this perpetrator going to be back out on the streets again? It's the memories that victims live with every day, and it's basically re-traumatizing them. And that's what I'm talking about. It's not the ability to go before a board. We know that's there. It used to be there back then too. And we actually, in previous sessions, had a person come forward that had to relive every few years the killing of her sister in front of her at her home. Those things strike me that those are the people that we have to protect from being re-traumatized.
Anything else, committee members? Representative Caruso.
Thank you, Madam Chair. And I won't belabor the issue, but I just wanted to let you know that I will be voting against this motion. Yes, victim rights is what victim experiences and reliving, and the threat also of having this person in their midst again. But for the most part, when I look at what this is proposing, I feel that the DOC is currently utilizing many good functions such as split sentences and probation and good times laws and the SCCP, which actually trains the individual to come back out into society. But this would pretty much upend the whole process, create a whole new system with huge costs, huge time, huge staffing, a new board. And it wouldn't necessarily, as we heard from the DOC in the last work session, it wouldn't necessarily save that much time. I think that what they're doing right now is working, and it serves similar purposes. And it was put into place by many, 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 many meetings versus what preempted this. And so I just think it needs to be really well thought through if this is going to be implemented in a future date, and have all the different stakeholders have really look at the entire system, as you have mentioned, the different conflicts before it comes back. Thank you.
Thank you. Anything else, committee? Senator Hagan?
Yeah, I'd like to respond also in support of Representative Poirier. Speaking before a board, we've all done that. Boards generally are there, they listen, they do their diligence. Thank you for that. Okay, see you later. These people are victims. If they've had to endure things that they didn't want, they didn't bring upon themselves, and all of a sudden they're forced to go into it. So to me, that is not an argument at all.
Anything else, committee members? Is the committee ready for a vote? Thank you, Clerk Panet.
You, Madam Chair.
You redo the.
Yeah, so the motion was Representative Lee ought to pass as amended. And who was the second again? Representative Sato? And it's as written on the yellow sheet that was distributed this morning. Everybody's all set? Thank you.
Senator Carney.
No.
Senator Carney votes no. Representative Kuhn.
No.
Representative Kuhn votes no. Senator Hagan.
No.
Senator Hagan votes no. Representative Poirier.
No.
Representative Poirier votes no. Representative Sinclair.
No.
Representative Sinclair votes no. Representative Pugh.
Yes.
Representative Pugh votes yes. Representative Henderson. Representative O'Halloran.
No.
Representative O'Halloran votes no. Sorry. Senator Talbot Ross. Representative Lee.
Yes.
Representative Lee votes yes. Representative Sato.
Yes.
Representative Sato votes yes. Representative Babin.
No.
Representative Babin votes no. Representative Caruso.
No.
Representative Caruso votes no. Representative Dana. I'll recall the absentees. Representative Henderson. Representative Henderson is absent. Senator Talbot Ross. Senator Talbot Ross is absent. Representative Dana. Representative Dana is absent. Madam Chair, I have 3 members voting in the affirmative, 8 members voting in the negative, 3 members are absent, and that is the vote of the committee.
Thank you very much. And so for those who voted against the motion, I'm going to ask you to articulate your report. We'll start with you, Representative Poirier.
Ought not to pass.
Okay, so for all those who voted no, who are an ought, actually, I'm just going to go around the horseshoe. Ought not to pass for Representative Caruso,
Ought
Representative
not to
Babin,
pass.
Representative Poirier. Representative.
Ought not to pass.
I will also be an ought not to pass. Senator Hagan,
Ought not to pass.
Representative O'Halloran.
Also ought not to pass.
Okay, and then Representative Sinclair.
Mine is ought to pass as amended. I would adopt the most recent set of yellow sheets. I would strike from section 5823 sub 1 on page 4, the last sentence, which begins with respect to.
Sorry.
And I
No.
would add in.
Hold on a second.
Apologies.
We're just trying to track you. Take us again. You're on page 4.
Page 4, 5823 sub 1, the last sentence that begins with respect to individuals. I would strike that entire sentence, which I believe removes retroactivity. And in whatever way is most appropriately OPLA-ized, I would add in the right to counsel at a revocation hearing.
So thank you for your report. And are you able to work with Eli to have that report transformed into a written form?
I'd be happy to.
Thank you very much. All right, I think that we have completed our work on LD 1941. We'll close that work session. And we're going to open up our next work session, which is on 2150. But before we do that, we'll just take a couple of minutes to shift our paperwork around, but we will get started very soon. Actually, we're going to have a 5-minute caucus break, so if committee members could return at 10:56. Yes. Committee members, if you could please take your seats around the horseshoe. We'll get started. We're opening up a work session on LD 2150. This is a bill entitled An Act to Establish Procedures for Restricting Access to State Property, Access to State Services, and Communications with or through state entities. And our analyst, Eli Murphy, has presented us with an amendment that I believe was worked on with the bill sponsor. Eli, would you like to review this amendment language with us, or could you
Sure,
please
thank
review
you.
it with us?
Absolutely.
Thank you.
So you should have, committee members, two copies of the same amendment. One is the yellow version that you generally see from myself. You should also have a white version with red text from the sponsor, which is the same text language. However, there are some additional changes that were requested in those comments, and so those presumably are going to be the points of discussion today. But so looking first at that yellow sheet, you're going to see at the beginning, in addition to the definition of entity of the state, and saying that except for the purpose of this section, a public institution of higher education is not an entity of the state. And so already we had discussed that public schools were not entities of the state. However, there was a request to pull out higher ed institutions, so that has been done. Some of the language in that subsection 2 for the notice of communication, it repeats the same language over and over again. Really, the purpose there from the request of the sponsor was that the really was that it's trying to cover the basis of whether or not a specific entity of the state issues these notices or communications, or covering the base of if it is the state police or another local law enforcement agency who are issuing on behalf of that entity. And so that language has been changed to just clarify there that it's regardless of who issues it, whether it's the entity themselves or law enforcement. There was discussion at length, and this is kind of the more substantive version or largest portion of the amended change. There was discussion at length at the last work session to change the procedure from the protection from harassment procedures to the ADC, the Final Agency Action Review within Maine's Administrative Procedures Act. And so what you first see there at the end of that subsection 2 is the sentence notice or communication pursuant to this subsection constitutes final agency action for the purposes of review under Title V, Chapter 375. And then there's also a notice that says for the purposes of this section, notice or communication does not include a court order. Just to clarify that any court order saying as such is not under review for this, etc. Moving forward to the subsection 3, the restrictions for 90 days. This is where in the printed bill, it discussed and posited the going through the PFH standard. And so there's new language after a hearing pursuant to Title V, Chapter 375. Again, that is that final agency review. And the main rules of administrative procedure, where that final agency review also has rules. A judge may issue an order extending a notice issued by an entity of the state restricting a person's access to state property or services provided by the state, et cetera, et cetera, et cetera, for a period not to exceed 1 year. And so that's that language I put in there just as a placeholder, which replacing the 90-day order and then the ability to go to a hearing to extend it, using that 1 year cap was, if I am understanding this correctly, that is the period of time currently that those orders are issued for. And so if the extension is granted, it would be granted up to that period of time in which a normal under today's laws issues would be ordered. The second major change, if you go onto page 2, is that new section 2, state police data collection. And I apologize for the kind of toner in this copy. I'm still working on trying to find the best way to give you guys the best legible versions as possible. But this is a list, and it is not in its final form on this this copy, which is why it looks a bit rough in terms of just listing things. But there are a number of data points that the sponsor wanted the state police, and in the comments on the new version, also the Department of Corrections, to collect with regards to these notices issued by or on behalf of state entities. Bunch of data collection, and then a report back to this committee with the ability for this committee to report out legislation similar to you would see with many report backs or legislative studies, that type of thing. So to implement a change, give it some time for that change to take effect, and then report back on data to the committee to see how is this working. From there, you will see the rest of the printed text is crossed out. Those are namely things that we're referencing the protection from harassment statutes, and so they're no longer needed if the committee is moving away from the PFH in favor of either something else or this ADC process.
Thank you, Eli. I'm going to ask you a question before opening it up to others. I see in section 2 of the bill, it refers to notices or communications. Can you just explain why there are 2 categories there instead of just 1?
That was the notice or communication was contained in the original bill. And so I left it as that was because there wasn't clear direction of whether it is just notice or if there's any other. To my understanding, after speaking with the state police, after speaking, hearing this work session, we are talking about 2 specific notices that are commonly used. Whether that means another form could be used, I'm not sure. I think the law specifically says a legal order or something to that effect. And so it doesn't, the language of or I guess the text of the law doesn't specify this notice or this notice. It has a broader category. So presumably there is a space where a law enforcement officer gives a legal order for someone to, cease harassment or to, vacate the premises for a period of time. My understanding is that would hold the same legal effect, even though it doesn't have a specific notice. My assumption is that a physical notice would follow, but under the text of the law, my reading is, it doesn't necessarily have to.
Okay, thank you. Committee members, questions for Eli about the amended version of the bill? Right. Yes, Representative Lee.
I'm puzzling through subsection 3 because the process that we've set there doesn't make sense to me. So it says, after a hearing pursuant to the APA, a judge may issue an order. And so judges don't generally have hearings pursuant to the APA. Is that trying to reference an ADC?
It is, and some of this language does need work, and I apologize. I was doing kind of a quick turnaround with a number of bills, so I put stuff down. That section, I've both questions for the committee in terms of what you want, maybe questions for the sponsor. The intention is to have it function through the ADC process. And so whether it is the judge who is giving an order or whether it does get kicked back to, I was looking through kind of the process in statute, whether it gets kicked back for the agency itself to revisit. But whatever the intention, my understanding, the intention of the sponsor, and I think of the discussions in the committee, was for it to follow as closely that ADC process as possible. And so deviations contained in this amendment that aren't specifically stated, I think, are there in error and should be fixed.
Representative Henderson.
Thank you, Madam Chair. Good morning, Eli. So in the yellow handout, I'm seeing obviously the subsection 3, but in this handout with the notes, it seems as though that there's a proposal to strike 3 altogether, which is that 90-day restriction, the court order, or the 90-day restriction is struck in subsection 2, and then subsection 3 is stricken altogether.
For that point, I would defer to the sponsor. That change was made after a conversation I've had with her. And so it may be in line with that same adhering strictly to the ADC and the APA process. but I defer to her. on
Thank you.
points.
Yes, Representative Caruso?
Could we hear from the sponsor to go over her proposed changes so we're not?
Yes, absolutely. I wanted to ask, and Eli, I would ask this to you, or whether it's a question for the sponsor. The section 1 of the bill, subparagraph 2, seems just really hard to follow. Do you think that that could be simplified so that, because I think the object of this legislation is to provide a clear process for unrepresented parties to be able to pursue on their own. And so do you have confidence that we could streamline it,
Yes, absolutely.
clarify it? Okay,
Yes.
thank you. Okay, the sponsor is here with us. Senator Grahowski, could you please join us at the horseshoe?
Good morning, members of the Judiciary Committee. Nicole Grahowski, I represent Senate District 7 in Hancock County mostly. Thank you so much for allowing me to explain my additional changes. Eli did some heroic work on a turnaround, but we didn't have a chance to go back and forth. So what you're looking at on the white page is what would have happened had we had a little more time.
So with reference to the yellow sheet rather than the white one, can you just take us through what you would consider still in and then what you would consider out of the bill?
Yep. So, and just so folks understand, the language and the yellow sheet and the white sheet is the same. I didn't do anything to try to edit Eli's work. What I did was I made all my proposed comments as comments. So it's, you don't have to be doing a version control issue. I think the biggest thing, I'm gonna go a little out of order, is that based on more conversations, which I'll admit to the stakeholders that have been really helpful, we haven't totally closed the loop on all of them. I think what I'm proposing to do here is a little bit of a vision change, which is we've got this ADC process. Let's make it easier and more obvious for people to utilize it. Collect some data from the agencies that are involved, have that report back to this committee at some period of time. Eli drafted it as 2 years. It could be longer if you think that's necessary for the Judiciary Committee to determine, do we think that worked? Or do we need to create an independent process that sort of puts the burden onto the state as I had originally envisioned? So I think, I mean, part of what's sort of come to light through this process is there are systems that could be improved upon, which is what the bill is trying to do. And maybe that will actually give people more due process in their experience and more understanding of what their rights are. And that might be an adequate solution. So instead of trying to recreate protection from harassment, but in a different way or what have you, let's just improve what we've got and see if that was good enough. So that's really the main thrust of the changes that I proposed, commented on in this document here. So that's why I was proposing to strike section 1, subsection 3.
Okay, so we're just gonna, I think that that seems to make a lot of sense. So give us a second to. And then can you talk a little bit about section 1, subsection 2, and just take us through the steps in a more just like bullet point type fashion so that we can grasp how the flow would go?
Yeah, so section 1, subsection 2 is really about the recipient of this restriction knowing why it happened and what they can do about it. But Eli's language does clarify some what I think were this sort of was loose language. So the changes are saying, you know, regardless of what law enforcement agency you are or entity of the state, you need to provide information to the person about why they were restricted and then what is their recourse. And so that is what that does. Where there's other language in there, it sort of tightens up the fact that we're talking about restrictions regarding places that the general public could go to were they not restricted. So it's sort of a subset of all state properties to the universe of ones that you or I could go into any given day. Maybe not any given day, but you could during open hours. So that's really the thrust of what those changes were doing. And I would just add that because of removing subsection 3, on the white sheet, you'll notice I proposed to remove the sentence that says, except as provided in subsection 3, and any of the state may restrict a person's access, blah, 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 for total period not to exceed 90 days, because I'm proposing that we remove that structure altogether. So that sentence needs to also be removed. And then I just had made a couple other notes, but maybe we see if anyone has any questions on that, and I can just touch on those quick other things.
Yeah, great. Thank you. And I know that Representative Crusoe has one for you.
Thank you. Thank you, Senator, for being here, for all your work on this. So regarding the first point, add a requirement that a law enforcement entity that issues a notice or communication shall notify all other law enforcement entities with jurisdiction. Is there currently like a mechanism for them to do that?
I appreciate the question. I don't feel that I'm the person that should answer that question. I added this here because what we've learned in digging into some of what happened is that all the entities maybe weren't sure what the other entities were doing. And it just made sense to me that if a person is restricted from all DHHS properties, that the local law enforcement, who would be the one that gets the call that says this person showed up here and they shouldn't have, would want to know that they had actually had the no trespass order. So it made sense to me that there ought to be this information sharing. I think it's a good question for Major Stevenson that I hadn't been able to circle up with him on to see if he feels that that is achievable.
Okay. So, and then also, may I have another question?
Yes.
The concept of providing info to the person on why they're restricted makes total sense. Is there, to your knowledge, is there anything that goes out now when that is issued? Like when that's issued to the law enforcement agency, for example, is there anything that goes out? Are you saying that maybe that same copy would go to the recipient, or what are you proposing?
So I'm proposing that the entity serving this notice would write on it or amend to it. So I don't want to be really prescriptive about that, though we could be. A short summary of why the person was restricted. And in talking with Major Stevenson, it seemed that and I don't want to speak for him, but I think what I hope I understood correctly is that there doesn't seem to be a big concern about being able to provide just a short summary without giving up anyone's personally identifying information regarding other people involved in the incident, but at least enough that the person would know, okay, yep, I remember when that happened and I know what they're talking about.
Okay, thank you.
Representative Poirier?
Thank you, Madam Chair. Thank you, Senator, for being with us. My question is regarding section 2, the data collection and the reporting.
Okay, yeah.
So when we're looking at this and it says state police, are we considering that it's only state police that can give these orders? I was under the impression that local police can also do that, and I don't believe that the database, like say Skowhegan would have for these sorts of things, link up to state police. They can't access that. So I'm just curious if we're collecting this data, is it going to be accurately reflected, or is it going to be skewed because the state police can't always see those notices when they're done?
Well,
on a local
thank
level?
you for the question, Representative. So this idea came about later yesterday than when I last spoke with Major Stevenson, so we haven't had the opportunity to touch base on it. But my hope, and it relates back to your question, Representative Caruso, is that if law enforcement agencies need to share the information with other law enforcement agencies that have jurisdiction in these locations, then the state police would always find out that these had happened because they have jurisdiction everywhere. And so therefore, it made sense to me that they could be the central entity for compiling that information. And I think that they do have an adequate, from what I can understand, documentation system that as long as they knew and recorded these orders. But it's possible that there could be a law enforcement entity that served one and didn't communicate it, and that could be missed, but the goal would be to tighten that up.
Thank you.
And the universe of orders that you're envisioning in this section 2 is orders issued by either a state, county, or municipal law enforcement office that specifically pertains to state property, right?
Yeah.
So it's not, it's within the scope of what the state police would be focused on anyway.
Right.
Other questions for the sponsor? Yes, Senator Hagan.
I have two things going back to section 1, but the first thing, I have hearing issues.
And the room has got it.
So if that mic could go closer to you, that'd be great. Just curious, excuse me. In the red on number 1, for the purposes of this section, a public institution of higher education is not an entity of the state. Just curious as to why that is there.
Thank you, Senator Hagan. And I think, well, I'll explain that and then make a short comment. I think what we had learned after the public hearing from information that was submitted by the University of Maine system, as well as later, I think the community college system, was they have a whole section of statute that says to them, this is the process you need to follow if you're restricting somebody on the higher ed property. So it made sense that because they already have the strict process, we didn't need to have an overlap. I do think now that the sort of 90-day test and then you go to the courts bit is removed, it might not be as consequential to exempt them, but certainly when that was envisioned, it made sense that they're kind of in a whole other universe of due process, which I think is awesome that they've got that codified. And I'm seeking to get closer to that with this bill.
Representative Lee?
I'm also thinking, and I'm wondering if you're thinking the same thing, that with, say, the University of Maine, that's not a similar place to DHHS where someone may need to go to do their regular public business. It's sort of a different kind of animal altogether than what we're trying to specially protect. Is that part of your thinking, or?
I think the university system it's all very interesting because they are public properties and they do have many areas that any of us could just go to at any time. So really for me, it was more about the fact that I didn't know that they had this whole section of statute that said, these are the really strict things you need to follow if you feel that you need to restrict somebody from a campus to protect student safety. So I think it was adequately addressed there. I would like to, if I might, make a comment also in this section 2. I had talked with Jill at the Department of Corrections and asked for Eli to consider, but again, with the lack of time to go back and forth, we didn't get it in this version, but I did speak with her and she's interested in this, so I want to float it all to you guys. Where there's the language around communications with or through an entity, there are different agencies that are implicated in the through concept, DOC being one, DHHS being another, where there might be an intermediate between two parties that want to communicate. And she gave me a lot of great examples about why it's important to be able to restrict outgoing communications from the prison to members of the public who might not be interested in receiving those communications. And so I had proposed that in the case of the DOC, that this bill not be considering that direction of through, if you will. So there's a different obligation regarding restricting an incarcerated person from communicating outward than the rest of the bill contemplates, but we didn't get that drafted in here, and I did want to make sure I spoke about that because I understand that that's still important to the DOC.
Could you, I missed part of what you were saying. Could
Yeah.
you reiterate it with just leaning close to the mic?
Yes, sorry.
Thank you. Just the simple terms of like what should be added.
Yeah, so where we're defining the communications with or through the entity as being one of the things that could be restricted. In the case of the Department of Corrections, just make it clear that that's one directional. So, and I'm interested in, if a member of the public, the outside, if you will, wants to communicate with a person on the inside, that they have the rights to understand why they've been restricted and transparency around what they can do to contest that. But if the prison system needs to restrict a incarcerated person from communicating with a person on the outside, that's not what this bill is about. So it's an exemption of sorts. Because
So
there's compelling reasons and sort of different standards for incarcerated people.
So there would be an exception, and that would probably be in section 1 of the bill. And that would be that it doesn't apply to restrictions that are applicable to residents of the Department of Corrections or a
That would be a
county
way to-
jail.
I think that'd be a way to do that.
Okay.
Yep.
Thank you. Representative Caruso?
Thank you. I guess I thought there was already, if there was a do not contact, that would already be instated from the court. So why would we need a new law to specify that? Like, why would we need to duplicate that if there's already some kind of restriction or restraining?
I think that is a question the DOC might be better positioned to answer. My understanding from talking with them is the court certainly could say and does say, these are people you can't communicate with. That doesn't mean that at some point during the person's incarceration, they may not decide to communicate with other people that the court didn't envision, but that the recipient might consider to be harassing.
Okay, thank you.
Yep.
Other questions, Representative Henderson?
Thank you, Madam Chair, and good afternoon, good morning, Senator. First of all, I really like the direction that this amendment is taking. It seems as though, like you said, there's just isn't a clear path forward right now in creating some framework. So I like this. My question is about section 2 when it comes to the data collection piece. So this specifically has to do with an entity of the state. And we've already flushed out that there could be an entity of the state that has multiple locations all across the state, everything from, say, DMV to DHHS. I don't know if we've talked about state parks, but I know we've got a bunch of those across the state as well. How do you envision state police communicating with county law enforcement, municipal law enforcement? Do you know if there is a clear mode for them to do so? Like, I know we have got a DMV office in virtually every town in our state, so we're talking hundreds, right? So I
My
think,
county would like there to be one in every town.
okay, so let's be a little bit
But
more
yes.
conservative, which I tend to be
Yes.
anyways. So a little conservative on that number. And let's say there's 100 DMVs across the state. How do you envision state police reaching out to every single one of them to let them know that like a certain individual doesn't have access to that?
I would prefer that the state police answer that question. I have ideas of how law enforcement in my world would be communicating with each other, but that doesn't mean that that's actually accurate. So I don't want to say something untrue.
That's fair. Thank you.
Based on my vision.
Committee members, if there's any final questions for the bill's sponsor, raise your hand, and then we're going to hear from the Maine State Police. Yes, Representative O'Halloran.
Hi, I'm just wondering if you're concerned at all of having the data collection piece on like a simple tool as in a trespassing order that doesn't follow anybody and it avoids an arrest, and it's an effective way to immediately resolve a conflict. And I'm just worried, and I don't know if you share this concern, that by adding that data collection piece, that we may be removing a de-escalation option, because if they have to go through all of this work, wouldn't it be just easier to arrest them? I just feel like, we're creating a lot of work for something that's just a simple, quick, easy tool that's been effective for a very, very long time.
I think it would be appropriate to ask the state police if they feel that this data collection is onerous and would shift behavior. I think in contacting was the Capitol Police like a year ago with this general idea, very quickly they were able to tell me how many of these that they had record of, right? So I do think this information is, to the extent, if it's not being completely compiled now, I'm not sure that it is hard to compile. So I think that would be a good question for them. The goal was for us to all have a better understanding around what this process actually looks like and is it being utilized? Because at the end of the day, the tool is very, very effective for those using it in terms of restricting people. What we don't know is it effectively being used and challenged when necessary regarding people's First Amendment rights. So there's this tension here that is different than many of the other instances where no trespass orders are used in the private sector, if you will.
You may, unless it's better directed at Major Stevenson. Okay, go ahead.
So part of this that I'm struggling with is the reason for this whole bill was on one department's lack of training or knowledge on how this worked, and they didn't reach out for help. Like, and I know we discussed this a little bit in the last workshop. I mean, would it be more effective to require training or even like a hotline number to smaller departments so they can reach out to the state police if they have questions on using this tool?
I think that's a better question for the state police regarding their the way that they liaise with the departments who are making these decisions. And I know I was able to look at Department of Health and Human Services has a really robust sort of protocol for these requests to be escalated from a local office up to the commissioner level and back and forth. So I'm not sure. I think what's hard about this discussion is the more that I look under rocks, the more I think everyone could benefit from a really clear protocol. And that's because members of the public reach out. You know, I brought this bill on behalf of a constituent and two of her loved ones that were also no trespassed. But that isn't the end of the story the farther that I get into this. So I think if there's a clear standard, then it's easy to train to that. If there's not a clear standard, then we're kind of leaving things up to folks to interpret the current process.
Thank you. Is this a question that for the bill sponsor rather than the state police? Okay, go ahead.
Thank you. So again, I really appreciate your thoughtfulness and all that you're contemplating. I completely understand the issue for transparency and making sure people are effectively communicated with if there is a no trespass. My concern is with on the second page, the section 2, the data collection. I'm trying to understand the why we need the policy, and 2, is the like how effective would this policy be for the purposes that you came for, and then also how can it be implemented? For the second, like the number of notices, that's a quantity, right? The number of notices violated is a quantity. The list of the entities, these are all concrete things. Geographic impact is kind of wishy-washy.
I think that's more of a drafting, just a quick
the request to me, and that is, as Senator Grahowski was mentioning, it's kind of a drafting thing of me not getting the best words out there. My understanding of the intent of that is the geographic impact in a sense of, is someone restricted from a specific area or from, all DHS locations? So kind of the how widespread is that restriction?
The scope of the.
Correct,
I
yeah.
see, okay. I just didn't know what the purpose was of just counting notices, like how does that help when you're trying to help the person who's receiving the no trespass?
Right.
Why does this, how does that achieve that? Like, why does it really matter?
I really appreciate that question, and there's a fundamental tension here around privacy. So I think it's challenging. I mean, the state police can't be very specific, I don't think, which is why I thought of these numbers and these answers would help us all understand what's the scope of the issue. Certainly being able to compare the number of notices issued to the number that were challenged in the courts would help us see if people are utilizing that process. But you're absolutely right, without specific information from specific affected individuals, it will be hard to know entirely if it is effective or not. But I mean, we're looking at bill and tax about tax appeals. And some of the data that we're looking at to help us decide if we want to streamline the system is how many of those go from a board to the superior court, and what is the result in the superior court. So sometimes we can't get more specific info, but at least you can get a sense of, all told, is this 5 people? Is it 500 people? If it's 500 people, did 250 of them go to court? If 250 of them went to court, did they all get a positive outcome? If they all got a positive outcome, then maybe for them, maybe we feel that it's really effective. But you're absolutely right. I guess we could ask the state police to ask people, do you want to share information about your situation?
So
That's a
can
little
I
awkward.
follow up on the policy?
No, let me just ask the sponsor a question because I think we need to move on so that we can hear from the state
Yes,
police.
thank you.
But so the purpose of section 2 of the bill is really to determine whether some kind of independent review process rather than the ADC appeal that already exists is necessary. And if the volume and prevalence of these orders would justify setting up a new state process, or whether the existing avenue for appeal, the ADC appeal, is adequate. Is that basically the reason why there's section 2 in here?
Yes, thank you, Senator. And I think if other folks have other ideas about what might help your committee and other legislators understand if the tweaks we've made, if this bill passes, have been helpful. If folks have other ideas about how to gather data about it so that we can have an informed consideration, I'm certainly open to that. This is just what I came up with as things that I thought would be interesting and informative regarding future decision making, but I'm not at all opposed to other ideas. But Senator Carney is correct that my goal was to help figure out if what we've done, if this does go forward, was adequate. And it might not be, but it's hard for me to prejudge that. So I was trying to get at data to help figure that out.
Representative Lee?
Maybe this is just, knowing not just the number of cases that get appealed via an ADC, but also knowing what those cases are. Because the second we get that, we have a whole lot of information on the individual cases, because we'll have the complaint and then potentially the decision. And that's not a long way to go, because all that's going to be public as part of the ADC appeal.
Okay, let's hear from Major Stevenson at this point.
Thank you all
you
so much.
for answering all of our questions, Senator. Good morning.
Good morning, everyone.
Could you please introduce yourself?
My name is Tyler Stevenson. I'm a major with the Maine State Police.
Thank you. Committee members, are there specific questions for Major Stevenson? Representative Henderson?
Thank you, Madam Chair, and good morning, Major. So you heard the question that I asked the sponsor of the bill. I really like the direction of this, and it seems like many around this horseshoe are data driven, right? And numbers tell a story. And we keep coming back to the example that was given for the precipice of this bill, but I think it's kind of uncovered more about the process than we knew, and now we're wanting to address that. But as we kind of step into this, how we collect data, as well as how your office would communicate with municipal law enforcement, is there some type of communication method that you have in place right now? Or do you envision there to be a way for you to be able to reach out? And I did look it up. There's only 41 DMVs across the state, so not one for every single town. But even still, that's 41 municipalities, right? There's 8 DHHS offices, 32 state parks.
Let's let him
so-
answer the question, because I feel like we're going down a different direction and we might lose our focus on the question.
Great. So do you have any type of an idea on how you'd communicate to the plethora of offices I've just laid out?
Well, I appreciate it. I learned something today. The answer is for the purpose of a no trespass order, which is the statute doesn't even require a piece of paper, is communicated. But it memorializes it for the police department and for the entity requesting it. It is not something that is put into a database somewhere or into NCIC. So when you run a person, you see it, it is kept in-house. So there is no good way to communicate that other than the old-fashioned way of looking up every police department. You forget about the 16 counties that would also have jurisdiction there. And then you mentioned BMV, which has its own law enforcement. So they very well could be issuing the order, not us. And so then they would have to communicate that to us if BMV was to do that. Honestly, looking at the amendment here, which I think has come a long way, and I appreciate the hard work on it. That is probably my biggest hangup, is if it is an individual building, state facility, or state park, that's not that of a lift to make that notification. You're talking about the state police, the county, and if it's got a local municipality police department, that police department. If it is a statewide, like a DHHS, if you're going to be trespassed from every building statewide, that would be a tremendous lift, because I don't even know how many buildings they have or where they are to make that notification by email, I guess. But there's no like easy switch to do that.
Representative Sinclair?
Good morning, Major.
Good morning.
There already exists a statewide mechanism for informing all law enforcement about PFAs, right?
Yes.
And there already exists a mechanism to inform all law enforcement statewide about bail conditions, right?
Yes, but can I clarify? You have to individually search that person. We don't get a notification of every PFA that is issued every day in the state. We do get a notification if you encounter that person and you run them through this.
Sure. So there needs to be something that's being investigated.
Yes.
And someone needs to check and they see, okay, this person isn't supposed to be here, right?
Yes.
And in fact, bail conditions can include location limitations. Like this person mayn't be within 100 yards of name the location. Does it
Yes.
seem to you like the restrictions being contemplated in the bill are that dissimilar that we couldn't leverage that exact same infrastructure for this new purpose?
For a major in the state police, that seems possible. I don't even know what that mechanism would be to be able to authorize law enforcement to enter that into the metro system, but maybe it's possible.
Committee members, I have a suggestion, which is that it seems like we're at a decision point of, do we feel that we have enough language and detail to vote on this legislation today? If we do not, my suggestion would be that we table this legislation and have the sponsor bring us back kind of the final version. And then we can vote on it at that time, because I feel like we're asking a lot of the same questions, then they're all unknowns. And the question is, do we need to know the nitty gritty of how the process would work? Or do we feel comfortable voting on it now and letting the state police establish a process? Representative Poirier.
Thank you, Madam Chair. I'd be comfortable voting today, but as with the last bill, if there are changes in language to tighten things up, make it better, we can always do the reconsideration. That way we're doing what we're supposed to be doing, getting this work wrapped up and not having continuous work sessions.
Yeah, thank you. I very much appreciate where your heart and head are on that one. Okay, yes, Representative O'Halloran. Yes, but can you just wait till we finish this discussion? So do committee members feel like they are close to being able to vote today, in which case we'll allow another question or two to the major. Okay, great. Representative O'Halloran, you're next, and then Representative Caruso.
Thank you. So as I'm listening to this today, I am curious on your thoughts because right now you can track arrests very easily when you're coming into an individual. So do you feel, because it sounds to me like this conversation is moving more to pushing arrests versus a quick de-escalation tool that you can handle at that moment in order to truly be able to track it, even for data?
I honestly, I don't think the police officer is gonna even think about that. Be more the administration, me, that is gonna have to track that data. I think that they're gonna do whatever they feel is reasonable to handle the situation. I do have a suggestion to make it easier to track, is if the entity that is issuing the no trespass order is other than the state police, if they could just notify us and then we can keep tabs on it, and it's good for us to know that a state facility, someone has been trespassed. That is just one notification that needs to be made. And then that's pretty easy and not a real lift for the police department.
Thank you. That's a great suggestion. Representative Caruso.
Thank you. I'm not really ready to vote on this because I don't understand the policy on the section 2. I completely understand the transparency that we need to provide info to the person on why they're restricted. I don't understand section 2 for the data collection because I don't know how that helps the individual. If you could find out, as Representative Sinclair was saying, there's already mechanisms that are in place, and if it's probably an IT, I don't know if it's writing code or whatever it is to add this, but the data collection that's in section 2, is that something that you already have a way where you're collecting it, or it's an easy query to ask the program?
For our RMS, our reporting management system, we can do that.
Okay.
However, other local PDs, we don't have access to that information, where, again, if they notify us and we can start a number, we call it a case number, that this has occurred, then it's something that we would be able to track easily, just through a search.
Right, but you don't track the local PDs or the counties or?
No.
Okay, all right, I have a suggestion. Senator Hagan, go ahead.
Thank you. Thank you very much. I have two things. One, I'd like to corner caucus before we decide whether we're going to table or not, if that's okay. And then a thought popped into my head on all of this. I can get into lobbies without key cards, and people might not even be there. Is there anything here that addresses that? Are we familiar with? This might not be for you.
Are you talking about like restricted areas that you could get into?
Well, there's a lot of places, if I'm trespassed, say, to come to even this building, I can get in up to the metal detector. I don't need a key card for that. So I'm curious as to how it's, maybe it's a silly question, but if I'm trespassed, I could still get in places. So.
Yes,
is there an answer for that?
but that doesn't mean you're not in violation.
Yeah.
And subject to arrest.
Right.
But I think you talk about the human dynamic, the possibilities are infinite. But if you're trespassed from an address and you're at that address, then you're in violation.
There is an event scheduled for this room for noon. And so what I'd like to do is to request a tabling motion, and we'll just have to continue this at another time. And perhaps it can be after the sponsor brings us back, like the final amendment. And I just want to let you know a couple of things that I think would be very nice to include in the amendment. Include that it also doesn't apply to restrictions on people who are residents of jails or the Department of Corrections. Simplify subparagraph 2 of section 1 so it's easier for the regular person to follow. Delete the 90-day limit and section 3. Set for section 2. Oh, and then also require in section 1 of the bill an obligation for any law enforcement agency other than state police who serve a notice or communication on state property to provide notice of that to the Maine State Police. And then I would also say, it sounds like the state police is capable of tracking this. And so we could say within existing resources, and that way the bill would not have a fiscal note. And we could get this process established more expeditiously. So I put that all out there for a suggestion for the sponsor to work on. And I'll ask for a tabling motion. So you have to make the motion. I can't make the motions. Okay, is there a second? Seconded by Representative Babin. All those in favor of tabling? Yeah. And so there was a motion to second by Senator Hagan. Motion to table by Senator Hagan, seconded by Representative Babin, and it is unanimous of those present. And thank you very much, Major Stevenson, for joining us. And thanks to Eli and the bill sponsor for all your hard work. So our work session on LD 2150 is now concluded. Good afternoon, everyone. Welcome back to the Joint Standing Committee on the Judiciary. We're opening up a work session on LD 1911. We will momentarily open up our work session.
Welcome back, committee members. Going to open the work session on LD 1911. And I understand we have an amendment to review. Eli, do you want to walk us through that?
So I will begin walking through it, and if I need help from the sponsor, I certainly will ask that. Most of these amendments on this page that you, on the yellow amendment that's in front of you, you have seen already. As you'll remember, we've been kind of working on this bill, making some amendments, and then having a work session in kind of tweaking on the same product. And so a lot of these changes you already have. One major change that you will see on page 2, excuse me, is, excuse me, one moment. One moment, or one amendment that you will see on page 2 is the striking out of paragraphs C and D to the definition of eligible criminal conviction. And so this amendment would remove any, the substance of this is removing any class C or B crime as eligible to be sealed under this bill. So what would remain is all class E's with an exception, and then all class D's with a list of exceptions that are all specifically named in the bill. And we can go further into what the content is after we get through the first round of the amendment. Language has been taken out. You'll see on page 2 further down, language referencing those class C and B crimes that is no longer needed, as we've removed those crimes from eligibility. Removed or added Maine State Archives to the list of entities that receive notice of the automatic sealing occurrence. Striking judicial branch from the cooperation section, given that they are the entity that is doing the sealing. Again, adding Maine State Archives throughout, and some of this has been discussed already in committee. If you turn to page 5, there is some limited disclosure of non-eligible or limited disclosure of certain criminal convictions and eligible non-convictions. That language, I believe, was then in there at the prior one, which is criminal history and record information that is subject to a sealing order, must be disclosed in certain situations that are referenced in that section. The additional change or additional language that was added is the it is now it's not shaded, I apologize, but it is the section 8 of the bill and section 7 and 8 of the bill, my apologies, relating to professional licensing. And excuse me, I probably won't be the best person to explain what and why. We definitely have people in the room who can explain those bits as well. But so I guess broad over scope of what those changes are you're looking for. You also should have received, similar to a form that you've seen before on white, LD 1911 summary of amendments. That goes through from the beginning of our process amending this bill. It lists all the changes that were made as they were. I'm going to make a couple of corrections to that, given the information I just gave you. And so if you're looking at that sheet, on the first column, number 7, it creates a 15-year waiting period for remaining Class B drug felonies. That is no longer the case, as Class B crimes have been removed. On the second column, number 15, it states that the Bureau shall not disseminate information about sealed records to professional licensing agencies. That has been removed, and that will be, of course, explained by those individuals. And then finally, not contained in either of those documents, but if you did see your email where I emailed this amendment out shortly before now, there are 4, and this is an additional amendment that was requested by the sponsor. To that list of eligible criminal convictions, there are going to be 4 more Class D crimes added. Exceptions, yes. So these are if you go back to page 1 of the amendment, eligible criminal conviction, eligible criminal conviction means, and then you go to paragraph B, what this will look like is a conviction for a current or former Class D crime, except, and then it would list the following four Class D versions of these crimes. It would be Class D terrorizing, Class D criminal threatening, Class D criminal restraint, and Class D reckless conduct. And so,
Eli, could you do those again more slowly so that we can
yes.
write them? Thank you.
So all four of these are Class Ds. It would be terrorizing, criminal threatening, criminal restraint, and reckless conduct.
Yes.
So when you're saying that you're adding those four things, would that fall under B, and it would be, like 7, 8, 9, 10?
They would, either there or put right after just, it's, yes, a sensible yes. The order of those might shift a little bit, the 1, 2, 3, 4, et cetera, but they would go in that section, yes.
So they are exceptions from eligibility.
Correct. A conviction for Class D terrorizing, for example, could not be sealed under this bill.
Okay.
With that amendment.
Right, I'm going to go to the bill sponsor next, but first let's just see if there are questions for Eli on the information he has presented. Okay, not seeing any. Senator Talbot Ross.
Thank you, Madam Chair. I appreciate the opportunity to address you once again. I really want to take just a moment to thank you all for your patience and your attention to this important bill, for the excellent questions and discussions that have taken place. As a result of all of that, we're now at looking at this final amendment for our consideration, bearing no other changes that will come as a result of our discussion today. But I do want to also thank Eli and the OPA staff and so many of the stakeholders, particularly the Clean Slate Coalition that we've heard from them. And the Judiciary Branch certainly has been at the table, the Department of Professional Financial Regulations, most definitely, the Secretary of State's office, and many, many, many others that allowed us to look at the balance that's represented in this bill. As a result of these discussions, I just want to truly emphasize, and I hope that you can hear me, that I listened to you and against a little bit of hesitancy, really landed that the most important and significant change that we could make would be to automatically seal Class E and Class D misdemeanors. Misdemeanors. That's the only thing that's on the table in this bill, along with non-conviction results. So that's really, really important to understand. No part of this bill touches any felony charges or convictions. The decision to do that was not reached lightly. As you know, the intention of this bill is to offer relief to hundreds of thousands of Mainers in each one of our counties and districts who cannot achieve the goals of accessing quality housing, having good employment, allowing for family security because of low-level offenses that this bill will now apply to. These are low-level offenses that haunt people for years, if not lifetimes, after they've paid their debt to society. So we know that with the data that's been presented at various times, that a person with a low-level conviction or prior behavior after the waiting period has exhausted, they are no more likely to reoffend than a member of the general public after that appropriate waiting period. So I just want you to keep that in mind. And we did, we do have some information that I can share with the committee from the Department of Corrections on recidivism. I think that was part of a conversation as well, but that will prove what I say is true about the propensity for recommitting a crime. So I, just chronologically to wrap your head around it, the original bill was presented on January 8th. And then that original bill took into account a year's worth of discussions with the CRRC and other stakeholders. As a result of that discussion, we had 2 additional work sessions on January 15th, January 28th, and we further refined this with the help of, again, the Department of Professional Financial Regulations under the leadership of Commissioner Cohen. I want to just make sure that I think you were handed a white sheet that the judiciary did provide to us. And if you look at this white sheet, it's about the post-judgment motions to seal. This was information that we had requested, the coalition have requested. And it shows of the 173 petitions filed, if you're taking a look at it in 2025, for instance, 88 or 51% of those had been denied thus far. 51%, half of them have been denied thus far. So what this does tell us is that there's very, very few people applying for petition-based, and it demonstrates that even a majority of these individuals attempting to seal their records, they're not fully understanding the requirements for eligibility. Instead of delivering relief through this process for hundreds of thousands of Mainers who are eligible, 163,000 who deserve a chance at the existing petition process cannot deliver that for even 100 Mainers. I'll just remind the committee very briefly that we know that Maine can do clean slate. This is a process that 13 other states, Washington, D.C., Puerto Rico have already done. They unlock the potential of hundreds of thousands of people in their states for a better life. I also wanted just to mention that all of those states have been able to withstand a First Amendment challenge. I will say that any bill in the First Judicial Circuit, which covers most of New England and Puerto Rico, have been able to get these bills through. Puerto Rico actually seals non-convictions and misdemeanors in a clean slate process just 30 days after the completion of the sentence. We're asking for 5 years, of which during that 5-year period for Class E's and D's, and also the period of time for non-convictions, those records are open and foreseeable to the public. I also want to remind you that anyone can petition the court to ask for a hearing that would allow them the ability, if granted, to see a sealed record. So one quick piece just to reiterate based on Representative Caruso's question. Again, I want to say that the exceptions that are listed, Representative Caruso, all of these, as you probably well know, these chapters are referencing crimes against the person or family. And we just added 4 other crimes that would be would not allow someone to be eligible for sealing. And those 4 crimes of terrorizing, criminal trespass, and criminal reckless conduct, those come from a matrix that the Department of Health and Human Services uses in order to license direct care workers. And what we did is we got the matrix from DHHS that showed all of the crimes that make one ineligible to have a daycare center or work as a daycare provider and elder direct care workers. I got the matrix from DHHS and compared the matrix that would make one ineligible to get that license with our bill. Eli looked at the matrix and compared, and the 4 that we just added came from their list, so that everything DHHS has in their matrix that would make one unqualified for one of those licenses, we now cover in this bill. There's no contradiction at all. I also had a conversation with DHHS yesterday to address any concerns they may have. The only concerns that they had, they gave to me in a letter, and their concerns really, and I can share the letter with you. The 3 concerns that they had were really centering around crimes against the person and family. And I showed them within the bill all of the places that we had addressed each of their concerns and told them if they had any other issues with it to contact me, and I have not heard from them. So this bill reconciles all of the places in which licensing, occupational licensing, securities, financial institutions, insurance, and it covers all of our bases as it relates to any concerns about someone joining a board or getting a license. And I just hope that you take into consideration the where we started and where we've now ended in this bill. And I thank you, Madam Chair, for the opportunity to speak once again.
Thank you. Representative Lee?
I just have a question about the four new crimes. That terrorizing makes absolute sense to me. Criminal threatening makes absolute sense to me. Criminal restraint makes absolute sense to me. With reckless conduct, there's a domestic violence version, and then there's just a reckless conduct version by itself. And I'm wondering if this is intended to scoop up both of those.
Yes.
Representative Lee, yes, it is, and I'll let Eli further expand on this if he wants. In the matrix, it shows under reckless conduct that applies to any class. All of those four, they apply to any classification. So we're expressly making them ineligible in Class D because that's all that this bill pertains to. But in any classification, terrorizing is not would make someone ineligible to get a license. Did I answer the question?
But I think you did, and it's because you're looking at the matrix that does it. And I just reckless conduct, as I read the definition, is recklessly creating a substantial risk of serious bodily injury to another person. And it's just, I can think of a lot of scenarios that would fit into that, where someone might, in their early years, particularly when they're 22 years old or thereabouts, commit this crime. And I'm just trying to distinguish that non-domestic violence version of this as something that isn't also deserving of sealing. I'm not going to disrupt anything as a consequence of that, but I'm just trying to do that for myself right now.
Representative Lee, I deeply appreciate you making that point. Some of these things give me angst as well, particularly since we have, taken out the portions like you just mentioned, but as well as a simple drug possession. We have, that was something that, members of the coalition, myself as a sponsor, really wanted us to take a firm step forward, an intentional step forward, to point out that simple drug possession is not criminal activity, right? And that is a different matter that has different consequences, but it is not criminal activity in it of itself. So it pained me to have to not be able to protect those who have served their time, had a significant waiting period. We had put in 10, 15 years for these waiting periods, and they will not be eligible for automatic sealing in this bill, like the point you just made. So I appreciate it, Representative Lee.
Thank you. Are there other questions, committee members? Excuse me, for the bill sponsor? Okay. That's, Senator Carney.
Thank you very much. And it looks like you worked closely with the judicial branch to make sure that this was implementable. Can you just review the changes that you made, or at least the provisions of the proposed amendment that address that?
Thank you, Senator Carney. This new amendment doesn't touch the process that was outlined in previous iterations of this bill. As you know, the kind of sequencing of it is that we are looking, once the record has been deemed eligible, the judicial branch puts an electronic flag on that record. We are trying, we do accomplish in this version, and it has been the kind of the guiding light the whole time, that to modernize the process now that requires hands to touch records often. So within that petition process space, the hands are touching records in some cases. So this bill is attempting to modernize that process, allowing for less burden on the judiciary. So it puts an electronic flag on that record, and sends that information on a monthly basis to the SBI. SBI then updates its records, and then it forwards that order to Maine State Archives, but it also informs the individual that the record has been sealed. And it is designed to be efficient in that mechanism. What you see in the bill is that there's obviously I'm describing a presumptive sealing process. What it talks about in the bill is a sequencing of where previous records would be flagged. And so we don't put the burden on the judicial branch to do this all at once. The implementation date for the bill is 2028. That has not changed. And then the sequencing of records that you find on page, actually starts on page 3 and goes to page 4. That sequencing hasn't changed since we originally had meetings with the judicial branch, if I've answered your question.
Yeah, thank you. That's very thorough and very helpful.
Did you have any questions for the judicial branch or you're?
At some point, yes,
Okay.
but
Any other questions for the bill sponsor? Okay, not seeing any. We do have a number of folks in the audience here with us. If anyone would like to pose a question to any of the stakeholders, Representative Henderson.
Thank you, Madam Chair. I would like to hear from the judicial branch.
Okay.
Question from.
Julie Finn, could you join us, please?
Good afternoon, Julie Finn for the Maine Judicial Branch.
Good afternoon. Thanks for hanging out with us today. So this might have been a piece that I have missed. Has the judicial branch, looking at what the caseload or what the workload for this would be, has the judicial branch, do you feel as though this is something that you can assume within the normal duties? First, that's my first question.
Thank you, Representative Henderson. It's just, I recognize a tremendous amount of work has gone into this bill, including during the interim where we were included in a couple of meetings. And I also would like to make clear that the judicial branch takes no position on the policy behind the bill, on what should be sealed, what should not be sealed, who should be able to see sealed records, none of that. We are completely neutral in terms of that. What is and remains difficult is the execution of some of what's in this bill as it's currently drafted. I will say I just saw this new draft. It's the reason I have my laptop. It's easier to read on here. There is a section that was deleted that was problematic for us, so I'm not going to talk about that. But the automatic sealing contained in section 2403. Well, just to go back, and I think this committee is familiar with the enterprise justice, the Tyler product that we've been implementing for a number of years now. So that started in 2021 and it started only with civil files. So it wasn't until 2024, I believe, possibly 2025, that any criminal records became electronic. And as you know, during 2026, we've stepped up, the implementation has stepped up. And by the end of this year, early next year, we anticipate that all of the courts statewide, including the criminal dockets, will be electronic and will be controlled by the enterprise justice product that we've been implementing. So prior to that, all of the records are paper. And they're in different places. Some are in courthouses, some are in archives, some are in storage units. You know, there's a lot of paper and it's stored in various places. So the automatic review that according to the bill in section 2403 would happen monthly. You're looking back 5 years because that's the look back provision. So essentially anything from 2023 before that would be eligible at that point in time. I realize the language of the statute says that they're utilizing computerized process to examine electronic case records. That confuses me a bit because there are no electronic case records to examine at that point. Any files that we do have are on paper. And then in the following section, 2404, the phased ceiling, that is 100% a look back section. It goes back gradually through to 2005, 5 or 10 years at a time. All of those records are on paper. We do have a system called MEGIS, as you know, which monitors our records, but MEGIS is not files. It is not case records. The records are on paper. MEGIS can sort of keep track of it, can tell you what's going on in a given case. There might be some way to program MEGIS to identify some of the right cases for sealing, but then all of those files would have to be collected in order for sealing to be implemented. You know, and it will not be until a few years to come, given the 5-year look back, that there would be 100% electronic records to look back to. So the way the bill is currently drafted does create difficulties in terms of resources. It would be a tremendous amount of work to look at these files and to pull them and make sure they meet the requirements of the statute. A judge would have to issue a sealing order and it would have to be placed in the file and also indicated electronically. But the electronic notification follows the paper, at least with the older files. That may not be the case going forward, but it is the case looking back. So I do have to, we would need additional personnel in order to complete this without taking people out of courtrooms. We have, as this committee knows, already sort of short-staffed with respect to the courts, with respect to our clerk staff. We do not have available personnel to undertake this type of work, and it is a pretty big lift. That said, and last year, this committee heard a similar bill. The looking back, the 2404 part of this, which is looking back and sealing records, once they're sealed, they're sealed. And so some of those positions would be limited period or limited term, because once the job is complete, they wouldn't be needed any longer. So that's something to consider there. But I just need to, I've been sitting in a lot of work sessions on this, and I know the intent is to make this easy on the judicial branch and to have it be 100% electronic process, but I just have to tell you that we're not there yet.
Representative Henderson? Just a follow-up on that. So the reason I ask is I'm looking at a version of this that I could support, specifically the non-conviction piece, the automatic sealing for the non-conviction piece. Is there a way for you to delineate the two, the conviction and non-conviction, and what the kind of workload is? And are all the non-conviction charges also in paper format and stored differently?
So a couple things. One thing there's actually a separate bill for just the non-convictions that's in criminal justice. It's one of the 4 that's over there. As I recall, we could do some of that without, and I'd need to see final language, of course, but on that bill in criminal justice, which is similar to this piece, we could do that, but would need an extended effective date in order for our IT staff to be able to get it done. But there wasn't the kind of resources needed for that, certainly.
Would it be possible to ask her for the LD number without breaking committee rules?
Sure. It's LD 1918.
1918, thank you.
Are there other questions for Julie Finn? Senator Carney?
Are you able to describe for us an implementation timeline that would mitigate some of the concerns about dealing with paper records. So, I don't know if there's a way to do it that would take us kind of further into the future, but require less resources. So that's what I'm asking you to opine about if you are able to.
I was actually thinking about that and trying to sort of do the math and extrapolate into the future. I would need to consult with our IT staff, but I mean, if we're fully online by January of 2027, and then there'd be a 5-year look back, and to my math, that gets me to 2032. But, I'm not a math person. I think that's correct, but I certainly would welcome questions about that, or need to run that by some folks. But that would be 100, that when we get to that point, it could be 100% electronic.
Good to know.
Thank you.
Any other questions for Julie Fenn? Thank you for joining us. Oh, sorry, Representative Lee.
I'm gonna ask you a question that you're probably not gonna be able to answer.
Thank
In
you.
the event we were to push it back to 2032, would there be no fiscal note? No need for additional staff?
Yeah, I can't say, and if you thinking about it, if it were 2032 and you're looking back 5 years to 2027, I mean, that technically that also includes everything prior to 2027. So it would have to maybe there'd be just, I mean, to really look forward, it would have to be that 5 years have gone by, but not before a certain date as well. And so we are looking probably, because there may not be that many in that 1 month, So I can't say about the fiscal note. I will certainly, whatever this looks like in the final version, I will find out. And our tech people have been involved in looking at various drafts and are prepared to weigh in on that. But I'm sorry, I can't be more specific.
Representative Pugh?
Thank you, Madam Chair, and thank you for being here. I guess, can you just clarify for me, as part of this transition to a new system, is there a process that is digitizing records previously? I thought I had understood that there was, but is there not?
It's my understanding that if there is something pending in a matter, if the case, so it's cases that are not closed, then some of the legacy files are being scanned in. Is how we're handling that, because, things come up in those cases and they need to be scanned in.
I follow up.
Go right ahead.
But for cases that are closed, those will not be digitized under the current plan. They'll just remain paper. Is that correct?
That's correct.
Thank you.
Any other questions? Okay, thank you for joining us.
Thank you.
Is there anyone else oh, yes, Eli?
I'm just going to give a brief piece of information based on Representative Henderson's questions on LD 1918. So CJPS has 4 bills that they are working in timeline, really at the same time we're working this bill. These all came out of that criminal records report that you as a committee turned into committee bills. And so that 1918 was one of those bills that this committee turned into a committee bill and sent to CJPS.
Representative Crusoe?
I don't know how, I think it's germane, but I was looking at 1918. It's not really non-convictions. There's also deferred dispositions. So it's not exactly what I think your intention, Representative Henderson's intention was, but I'm not sure if you could clarify that.
I can't clarify, Representative Henderson's intention of what she would like to see in a bill. I think that bill, without, having the text in front of me, but remembering, is the intention behind that was to cover all of those instances except for the conviction itself, in which a record of someone's conduct is created in the criminal justice system from arrest through dismissal or whatever else happens.
Is it fair to say, Eli, that there is overlapping content between the different bills? And,
Correct.
okay,
It's my understanding of kind of the scheme of all of them is there is this large comprehensive bill in 1911, and then those other four, not fully, but they are some component parts or some kind of subsets of what would be conceptualized in this bill.
and I can share that I think CJPS has not initiated public hearings on those bills, pending what decisions come out on the bill that we've already been working. Representative Crusoe.
I don't know about the other ones, but 1918 is having a work session at 12:30, or did have a work session today. I had another question once you're done with this.
Yes,
for
Senator
Eli.
Carney.
I believe they were waiting to vote on the bills so that we could look at these all more holistically. And so I would say we should do our best work on this bill and then look at the potential overlapping subject matter at a different time.
Representative Crusoe.
May I change the subject?
Yes, please.
I have same bill. Eli, you forwarded a letter from Freddie Flaherty on the constitutionality of this, and I didn't know if you could speak to it or there's someone in the room that could speak to it. I had read through it in the last week and just wanted to bring it up for discussion.
Is that letter in our folders?
I'm not sure if it's in your folders.
Okay.
It was an email that I received that I did forward. It's a letter, letterhead Freddie Flaherty dated February 3rd, 2026. I would probably not be the best person to speak to this letter. I'm not sure if someone in the room could or is responsible for the letter, or someone within their organizations is responsible.
Is there anyone in the committee room? Would you like to hear from Judy Meyer?
Thank you very much for allowing me a moment to talk this through. So my peers at the Maine Press Association and I, we were curious that there didn't seem to be appetite to get an opinion on the First Amendment infringement on this bill. So we sought a legal opinion ourselves from Sig Schutz, who's a partner at Freddie Flaherty. And that's the letter that was forwarded to you. That opinion has been joined by the Maine Freedom Information Coalition, the Maine Association of Broadcasters, and the New England First Amendment Coalition, all entities that see this bill as an infringement on the First Amendment. And I don't think I need to read through it because you have the letter, you should have the letter. But there's a number of cases cited in the letter that are on point here. And I just also would like to point out that there's been a lot of talk about these 13 states that have adopted this legislation. New Hampshire, Massachusetts, and Rhode Island shield non-conviction data, not conviction data, which is in the bill before you. They seal non-conviction data only, not conviction data. So Rhode Island, Massachusetts, and New Hampshire. But in Maine, if you were to run a criminal background check through SBI, you're not going to get the dismissed cases back. You're just going to get convictions. So in Maine, we have a de facto program working this way already without touching the court records. It's just through SBI where you get that information. So we're already doing what Rhode Island, Massachusetts, and New Hampshire are doing through their sealing bill in terms of public access. Now, you can still go to the Kennebec County Superior Court, look at all the court files you want, so you could look something up. But in terms of these employment factors and housing factors where there's just a base criminal background check run, dismissals would not kick back. So they're already shielded under the current process. And if you don't have the letter, I am happy to go through it. Feels a little repetitive, but I'm happy to do it.
The letter is being copied now.
Oh,
It will be
okay.
circulated in just a few minutes.
Okay.
Senator Carney?
Thank you for bringing up the non-conviction data issue because I was mulling that over as well. And I guess my question to you or perhaps to Eli is I'm wondering if, because that information still might be available to somebody who went into the courthouse to look for it, if there are these data mining companies that are collecting that information and then putting it into their program that they sell to other entities who want to conduct background checks. I just don't know how complete a protection our current law is, I guess.
I don't have the answer to that question. That probably is a better question for Julie Finn. But I imagine that there are some data miners out there and it will become easier, obviously, as digital records move forward into the future, maybe 19 or 2032, but it certainly will become easier. But that could be said for any records across the board. So
thank you.
Representative Caruso?
Thank you. I'm sorry, I'm just not familiar with the process. Can we have an explanation of the dismissal process that is currently in place that you were just referring to?
So I'm convicted of a Class D misdemeanor. Okay, but not convicted. I'm charged with a Class D misdemeanor. I don't know what the list is, but think of the most horrid of them. That's me. I've been charged with that. I go through the court process. The case is dismissed. The record remains in the courthouse, but if I were to go look for housing or seek job and somebody were to seek my criminal background through SBI, that dismissal would not pop up. Only a conviction would pop up. So we're already parsing those two levels of records out through the SBI process. I hope that
Representative
answers your
Henderson?
question.
Yes.
Yeah. Okay.
Yes, thank you. That was helpful.
Thank you, Madam Chair. As I do, maybe once every month, I'll just remind you that I'm not an attorney. So did I hear you say that? I guess I'll back up. I'm looking for a path forward for the non-conviction charges, right? Did I hear you say that you feel like it's not completely necessary to have that piece, or are you advocating for that piece to be automatically sealed?
I share with you that I am not a lawyer as well.
Okay.
But what I'm saying is we don't need that piece if that's what we're after, because it's already happening through the way SBI is set up in Maine. Dismissals are already shielded at that higher level of search.
Unless someone physically goes to a courthouse
Goes-
to request the physical records.
Yes, and that would be a rare bird. I'm here to tell you
Okay,
that does that.
thank you.
Representative O'Halloran?
Is there already a 10-year look back in 17A, section 9A?
A 10-year look back for,
Because with the 10-year look back in 17A, section 9A, like there's on criminal records.
for when you petition for a file to be sealed?
Yeah, like they go back, you're allowed to be able to look back anyways for 10 years.
Here's Eli to the rescue.
Section 9A of Title 17A refers to an enhancement to a charge based on a prior conviction. And so that 10-year look back would be, say, I'm charged with, I'll use OUI as an example, though OUI does have some different, so I guess probably not a good one. I'm charged with theft, charged with simple theft. If I have a conviction for simple theft, I think it's twice within the past block of time, and under statute, it's that 10-year look back. So if I've been already charged with theft twice and I'm charged the third time, I could be charged with a new crime of theft with priors, which is just elevating that class from A, B, or D to C. So that's what that section refers to, is in the charging of a new crime. If you have priors, it can be elevated.
And so those wouldn't be sealed. For the prosecution, we already covered. Okay.
Yeah.
All right, thanks.
Are there other questions for Judy Meyer? Representative Lee?
I'm reading Sig's memo and I'm trying to square this Pokaski case. And so it seems like the concern in the Massachusetts court was sort of like the categorical sealing of records without the court making some sort of finding. Here, as I understand it, we're setting out a process in which the finding is that all of these qualifications have been met and none of the exceptions exist, and then the sealing happens. And so the court would still be doing something. It would be acting and I think Julie said you'd need a judge to act. And so I'm just trying to see how Pokaski is still applicable to this situation. And you said you're not a lawyer, and I'm asking you.
Yeah. And I would need Sig to fully answer your question beyond what's already in the memo. Apologize for that.
Any other questions? Senator Talbot Ross?
Thank you very much for being here, for all your work on the Criminal Records Review Committee over the years, and for our conversations of late. Do you know if any challenges to New York, Oklahoma, Kentucky, or Mass have First Amendment challenges have been able to be successful in those other states?
I can't answer the question once the laws were enacted. I know there were challenges in the building of them, which is why they probably take the shape that they take now. But I don't know that I can answer that with any clarity, because as you remember, we didn't really dive into what each state did and how they got to that point. I think that was on the assignment sheet and we just never quite got there with criminal records. But I think it would be a review worth having, is looking at the process of how these states came to be.
Thank you, Ms. Meyer. I would just, thank you for answering the question. I would just say to the chairs, I do have that information, and there is someone who could provide it to the committee if the committees would like to hear from him about these constitutional challenges, as well as talking about the automated system that the previous conversation. So he's ready to answer those questions and make some comments to this committee.
Is that Ryan Ewing?
Yes, it's
Okay.
Mr. Ewing. He's standing by if the committee chooses.
Let's just see if there are any more questions for Judy Meyer. Not seeing any. Thank you for joining us.
Thank you very much.
Ryan Ewing, you're being brought over. If you could activate your camera, please. Yeah. Oh, thank you. Representative Pugh?
Thank you, Madam Chair. Is it appropriate to ask a different question while we're waiting? Oh, never mind. I'll come back to that. Thank you.
Thank you. Welcome, Ryan Ewing.
Well, good afternoon. It's a pleasure to be with you. I wasn't expecting to be on camera today. I'm sorry, I just got off the road from some other travel. So pleasure to be with you today. I've been following along, not on Zoom.
Could
but
you
on
just briefly introduce yourself?
Sure, I'm Ryan Ewing.
Thank
I'm
you.
campaign strategist and attorney with the Clean Slate Initiative.
All right, thank you. Please continue.
Yeah, absolutely. So I've heard two discussion points as I was following along with the live stream. Just got the Zoom link. Apologies for the delay. Would love to address in whatever turn is best suitable the constitutionality questions around the First Amendment, as well as the issues around the process, which I think there's still maybe a fundamental miscommunication about what the bill intends in that regard. I could start with First Amendment issues.
That'll be fine.
The the representations in the 2016 letter that was shared, as well as this more recent letter that was shared, cite to some federal case law, and I know a few folks are attorneys on the committee, but the federal case law comes from a circuit court decision in the First Federal Circuit, as was provided to the committee, I think, following the first work session or in the first work session. Federal circuit cases are not binding on the states. They are suggestive or persuasive authority, but they're not binding authority. And since the time of that case in the 1980s, I think it was 89, the Globe case, Massachusetts has diverged from that train of cases. And so in that line, Massachusetts state courts have decided independently that we understand what you're saying here, but we are not bound by it. And we are intending to pursue record sealing in an automated fashion because of the societal interest. That is a permissible interest, and we can do this in sort of the presumptive fashion. So just as this bill outlines presumptive sealing, they in Massachusetts have also said we can presumptively seal certain non-conviction results. Those include acquittals and no true bill. Those are automatically being sealed today in Massachusetts. There was some representation of other lines of argument in different cases, but based on that proposition, state of New Hampshire is doing automatic sealing. What they call annulments, which is more akin to an expungement. It's a full and complete erasure of non-conviction results of any kind. In Rhode Island, they are automatically sealing non-conviction results, and they're automatically expunging cannabis offenses, which are no longer a crime. Additionally, in the I guess it's not a state, but in the territory of Puerto Rico, in 2024, they passed legislation there that is what we would call a clean slate bill. We don't typically list it because of its territorial status, but after serving the sentence for a misdemeanor, as long as you don't hit certain qualifications, that misdemeanor is automatically sealed 30 days after the completion of sentence, and all non-convictions are automatically sealed. If there's ever a more clear example of a federal enclave or territory falling under the First Judicial Circuit, it is Puerto Rico. And that law has not been challenged as being unconstitutional. And so there are numerous examples of how, yes, it's persuasive authority, but it is not binding, and states are choosing to go in a different direction with that. If it were two lawyers arguing this case in front of a judge, the judge would hear these arguments out and make a decision. I'm not expecting this committee to necessarily debate the constitutionality of it, but just know that other states and territories have done this law, and it has not been a problem even in the First Judicial Circuit. The closest neighbor that you have right now is Connecticut. They do have a clean slate law that's been fully implemented, and they're meeting with great success. So that's what I would say on that topic. As to the process itself, when it relates to court records, again, I hear what Ms. Finn is saying regarding the court process, and I think the fundamental miscommunication we're having, and we sat down and talked at length over 2 different meetings to talk about the process, to shape the language in the bill itself, and to talk about presumptive sealing as a process to envision, because it is different than petition-based sealing. Petition-based sealing often takes an individualized review of paper records, makes accounting for certain waiting periods, looking at the actual completion of a sentence, and then counting the days from that completion. When you do an automated process, not only do you not need to touch paper records, but it's antithetical to the process to have to touch paper to produce and find these pieces of paper in different archive locations. If as described in this process, we are ending up with something where a court is individually making court orders, printing that court order and putting it in an old paper file in order to seal the case, that is not automation. We would not call that automation. What we are intending to do with this is to use the existing technology and leveraging the new technology systems that the court system will have to put a digital flag on the case. Now, it had been discussed as to whether or not folks are going to courthouses to get information. So there are two places where data about criminal records are held, the courthouse and the data repository. And in the courthouse, if there isn't an online digital case search tool, which I don't believe Maine has, I think people are still going down to the courthouse to get their information. And so what would happen is if you're not able to find it online, you go to the courthouse, you're asking in Kennebec County, I want this case from this year with this person, and the court clerk will produce that file for you if it's a public record. What we are saying is that at that point of contact, when they're looking up the name in the computer system they have at the clerk's office, a flag appears on that and says, do not release this information. That is all that you really need to do to prevent the court runners that go around and collect information from getting it. And as long as there is not a public terminal that they can otherwise access, that is the step that we're looking to take. And so in many states, I'm working in Kentucky right now, they actively have court runners going out to the 120 counties in Kentucky and pulling case files. And they do that as part of their background check process, and they get paid good money to do it. The other source of information is the data repository, the centralized data hub that in Maine is hosted by the SBI. Now, the court system does have a direct data uplink with SBI. So when a court seals a record, that information is almost instantly transferred to SBI. And there it is the SBI and their repository information, which gets shared with the other states and through the federal compacts that are part of data sharing. And so as long as we prevent that sharing from SBI and prevent the court runner or the person from getting the thing at the desk of the courthouse, you have effectively completed a digital expungement, sealing process. And so that is all you need to do. We are not asking the courts to pull old files or do anything with the files. We don't want the court to print an order and put it in the file. We are asking the court to do omnibus orders if needed, applying that across the course, and then applying a digital flag. Between those two processes, this has worked effectively in many other states, and that is the design that we are trying to create for Maine that is catered specifically to the data needs of Maine. And I'd be happy to elaborate further if you wish.
Let's see if there are questions. Committee members, Representative Sinclair.
Thank you, Madam Chair. Good afternoon. I don't know if you heard Representative Caruso's earlier question about successful deferred dispositions that as the good outcome result in a dismissal. I understood her question, and I apologize to the good representative if I'm wrong, but it may help the conversation anyway. I understood the question to suggest that those ought not be included in conversations of non-conviction data. Of course, in Maine, there is no conviction until and unless the court imposes a sentence. So technically they would fit in. I'm wondering if you can tell the committee how for those states that have already implemented clean slate, whether they include their version of a deferred disposition that ends in a successful outcome, or whether those are excluded.
Yes, it is entirely shaped on how the state itself handles those cases. If it's a deferred disposition, deferred prosecution, some people call it the STET docket. In Maryland, if you get placed on a deferred disposition or STET docket, for instance, there is a 3-year waiting period, and the court could bring it back up in those 3 years. But after the 3 years has elapsed, it cannot be brought back up, and it can be dismissed as in any other non-conviction outcome. I understand that in Maine, it is a question of whether the prosecutor would formally make a motion to dismiss it at the end of a successful period of deferred disposition, or whether the charge itself, a conviction, would go forward. And so it seems to be the only two paths are, you're getting a conviction or you're getting a dismissal. And so what is envisioned in this bill is that there is nothing that happens with that deferred disposition until it is over and dealt with. And if it is a non-conviction event at the end, then it would follow the non-conviction rule. If it is an eligible misdemeanor conviction, it would follow the misdemeanor conviction rule. And that's the simplicity of it.
Other questions, Representative Lee?
Trying to puzzle my way through the First Amendment discussion. And I think what I hear you saying is there's case law on both sides. It's resolvable as sort of an argument. It's potentially could be litigated. What I'm having difficulty understanding, especially in reading the memo that was presented to us, is there seems to be implied that there's some consequence to whether or not we're talking about post-conviction or pre-conviction information. And I just don't understand how that has bearing on the First Amendment question, which I understand to be whether or not there needs to be a case-by-case assessment of that question of whether it should be turned over or not. And can you help me out there? Because
Sure. Well, I think that is rooted in a historical dichotomy between whether or not a conviction record could ever, be expunged. You used to have motions to vacate a conviction, and that would be the only way that that conviction went away. And as time proceeded since the Globe case in '89, more and more states were considering the sort of the cacophony of collateral consequences that happen with carrying a conviction or non-conviction record, because they are appearing on what we call the rap sheet. And so when you apply to housing, when you apply for employment, even those non-conviction results are showing up. And sometimes the charge screams louder than the result, right? You may have been charged with a serious offense, but there was absolutely no proof, and it resulted in an acquittal or a dismissal. And so the real problem there was that the court in Globe was looking at non-conviction process, because that was the only thing people were doing then. And I would say that in those years hence, that the evolution of thought around what these records mean and whether you could address it on a case-by-case basis has totally evolved. And this the rapid dissemination of this information throughout the United States as a result of the past, 30 some years since Globe, that is a totally different animal than what they were dealing with then. And so I guess to answer your question in sum, the initial thinking was only about non-convictions because that was the only thing that people were automatically or trying to automatically dispose of. Since that time, that thought has evolved.
Yep, go ahead.
just to make sure I understand what you're saying, the First Amendment question sort of exists irrespective of whether we're talking about pre-conviction or post-conviction.
Correct. Yeah, it's a First Amendment argument sounded in the access to court records, which is an important consideration. And the earlier line of argument was that you shouldn't presumptively seal. That's what GLOBE stands for. You couldn't presumptively seal that, but rather you could only seal after an individualized review. Well, at the scale of criminal records today, at the sheer numbers that you're just looking at in Maine, you could never do that at scale. It would take 80 or 100 years to individually review all of these cases. And so when you're looking to do this in a widespread way, it just isn't feasible. And the courts have recognized that evolution. And even the Massachusetts courts have deferred from their federal counterparts and saying that we can do some of this here in Massachusetts.
Thank you.
Yeah.
Other questions for Ryan Ewing? All right, thank you for joining us.
Pleasure to be with you again. Thank you.
Do committee members have questions for other folks in the room? Yes, Representative Caruso.
I'm not sure if it's Cleveland or something else from the judicial branch on. I wanted to know about the process.
Could you put your mic on? Sorry. Yep.
I wanted to know about the process for how motions to seal are granted now versus what this is asking for. I'm not sure if Julie would be the right person or somebody else.
Julie Finn, do you want to try to answer that? And then Representative Pugh, you're next.
So I see this chart
that was given to us. And I'm trying to get a vision for what we're doing right now. I learned that we're already dismissing non-convictions. And I don't know if that's what Representative Lee was saying, was this pre or post, what? And then also what the process is for sealing now.
So Julie Finn for the Maine Judicial Branch. The current process for sealing is in Title 15, Chapter 310A, post-judgment motion to seal criminal history record. And so what the chart that you're looking at, which is titled Post-Judgment Motions to Seal Criminal History Record Information 2024 to 2026, describes how many were filed in a given year, how many were granted, denied, withdrawn, and pending. So what happens in those cases is someone files a motion or a petition. We have forms for that. I think you've previously been distributed the form, maybe in a prior work session. I think it's CR 218, which is linked on a web page that the judicial branch has put together, which describes the sealing process. It has links to the forms. It's pretty descriptive. So the individual files the petition. What's listed on the petition are basically the prerequisites contained in the statute, because in order to get the petition granted, you have to meet the requirement set forth in the statute. And then it is scheduled for hearing. I believe the statute says that notice goes to the district attorney's office. I'm not sure if they always attend or not. And then the judge really is looking to see if the statutory requirements are met. And so if a case is denied, my assumption would be is that the statutory requirements were not met. These numbers they went up in 2025. I actually believe that's probably as a result of the work of the Criminal Records Review Commission, who one of their recommendations was for this to be sort of highlighted and raised up on our website so it's more visible, and to create a separate page and to set forth the requirements more simply. It's written in a very concise manner as well. So I'm not sure if I answered your question.
That's good.
Could you put your mic on if you have an additional question?
Yes, thank you. No, it's helpful. Thank you for explaining that. And I'm sorry, I forgot if we already went through it in the past work session.
No, that's okay.
And so currently, non-convictions are being dismissed automatically.
This doesn't have, the petition
Not that.
process doesn't have anything to do with non-convictions.
But from what we heard earlier today, already Maine dismisses non-convictions. They're not included in the SBI.
That's really a question for SBI as to what's included in the
Okay.
SBI. I'm sorry, I'm not being helpful on that. Or maybe Eli.
So not a full answer to that, but what might bring a point of clarity is a non-conviction is a dismissal. It's, I guess, if you're looking at it in a black and white way, you have a criminal charge, it either results in a conviction or a dismissal. And so to make that blanket of non-conviction being dismissed, it's by default, that's what they are. Whether they show up in an SBI report certainly can be, I don't know where she is, she's behind me, can be answered kind of in a more meticulous way of what exactly and how exactly that functions. But with regard to whether anything that is non-conviction is or isn't a dismissal, that's what that is.
Representative Pugh is next.
Thank you, Madam Chair. And this is really for you, Eli. I'm just trying to close the loop in my own mind on this paper versus electronic records. And in rereading this right here, I'm on page 3. I'm looking at 2403 and then 2404. My reading of this is that this specifically names electronic case records, so that anything that it's requiring the judicial branch to do only then applies to those electronic case records, so it wouldn't actually apply any of these requirements explicitly to paper records. And as I go through to 2404, it explicitly says, so for instance, number 1 under A or B or C says, the judicial branch shall seal electronic case records, and then it will be removing access to information stored in electronic databases. And then below that, it says physical records will be handled on a case-by-case basis. So I just want to understand that if my reading of that is correct, in that the requirements laid out here would only apply to explicitly electronic records, and that paper records, there's no requirement to go back and do anything with them. They're actually handled on a case-by-case basis. Is that correct?
Well, that is what is stated in section 2404. It's creates, I guess, a point of question for us, because there aren't any electronic case records that go back during the dates that are set forth in the statute. So I'm not clear what they're talking about there. And then another point is, if there's an electronic case record and a paper case record, I think we would want to make the point that it is important that they be the same, because that could really create problems down the line. If some person is looking at one versus the other, and that in order to remain consistent, as long as we do have paper case files, they need to be complete and contain any record of sealing. But we don't have electronic case records in the criminal cases at all prior to 2024 or so.
Follow up, go right ahead.
I guess my reading of that is, then if there aren't any records, that is not creating a requirement of any kind. And I guess I'm wondering on, for instance, on the second point there, in section 3 under A, B, or C there, it says, after corresponding physical records shall be handled on a case-by-case basis, with verification that each record corresponds to a sealed or expunged electronic record before any information is released. Is that satisfying that second point that you made, that requirement of consistency between paper and electronic records?
So to me, it's confusing there, because there aren't, and you look at the dates that are set forth, perhaps because under A, there are a few electronic records that would be, but under B and C, there wouldn't be any. So physical records are the only records that we have. I'm not sure what it's asking us to do, because it is talking about sealing case records and corresponding physical records. It was our interpretation that the judicial branch would be expected to seal the files in whichever format they appeared. And that in any case, if there is both an electronic case record and a paper case record, which that it's, doesn't happen often, that they need to be consistent and they need to be the same, and not just in one place or the other.
So would that interpretation almost mean a de facto delayed implementation date to 2032? I mean, if you're interpreting it as only being electronic records, if I'm understanding your question, Representative Pugh?
I guess, yeah, that's sort of what I'm trying to get to the root of. And I guess one scenario that I'm envisioning is that in the future, there might be a retroactive system to digitize everything. And at that point, you have this monthly review that would then go back. So I guess I'm reading these as, say this is on the books, and then sometime in the future, all the records are then digitized. At that stage, then this requirement would kick in, because you're dealing with electronic records where there is the language that compels the judicial branch to do something. But I guess I'm just not seeing that that it applies to the paper records. So I'm kind of trying to suss that out.
Mm-hmm. Are there any other questions for Julie? Okay, not seeing any. Thank you.
Thank you.
Oh, yes. Okay. Representative Henderson?
Thank you, Madam Chair. So it is, went through Representative Pugh's line of questioning. And you may have already explained this, Senator, so please forgive me. When it talks about paper records being handled on a case-by-case basis, is it just when information is requested about that individual? That is when, like, what would be a case-by-case base? Like, what's the definition of that? Do you know how that came about?
Thank you for the question. I will try to get Ryan back on the Zoom to answer that more specifically, but clean slate is not about paper records, so this corresponding physical should be handled on, that's with, yeah, we'd have to get Ryan Ewan back on. Yeah, and I just wanted, one of the other points, I think it may be, Ms. Finn is saying that it's confusing about in section A about eligible electronic case records. I think she'll see electronic case records. She's saying that there are no electronic case. I think this is referring to the electronic docket. This is, so if we can get Mr. Ewing back on the phone, he can explain this in more detail. I'm not an attorney either, so I cannot answer your question.
Would you like to ask that question?
I'd like for the clarification to be made.
Yeah, I think so, and I think, yeah, I think I'm still a little bit gray on electronically exactly what records are being held in the main judicial branch electronically. So that might be partly for Julie, but also I think the piece on the actual paper, like what does case by case mean? In what way are they going to be?
All right.
So maybe that's two different parts. So yeah.
Pause for a moment.
Yeah, and I appreciate, the only thing I'd say is that this paper trail, the scanning of paper records is not relevant to clean slate. So he can further expand on that.
All right. Mr. Ewing, you could, okay, thank you.
I'm back. Thank you.
Do you need the question restated or?
I
do you
think
know
I
where we
heard
are?
most. I think I heard most of it.
Okay.
And so, in terms of the electronic case record, yes, that is really about the docket entries that are electronic and putting the flag in that database first and foremost. Electronic records more broadly moving forward, yes, that is how the Tyler technology software backbone of the court system will be working. There was never an intent for them to have to go back to any paper record and make any changes there. The language about reviewing paper records on a case-by-case basis is really about Maine's existing sort of sealing process and the court rules around electronic access. And so a person can request a file from the courthouse, and at some point in the future, maybe there's envisioned that there'd be a public terminal, but regardless of a public terminal or speaking to the clerk directly, if it is determined based on that that electronic docket entry that this is a flagged case, we think it is a clean slate sealed case, presumptively sealed, then there would have to be the determination. So if someone from the public was petitioning to open that case or get the information of that case, that is when the case-by-case determination about the paper records would really occur. I think that answers the question, but if I misheard it.
Representative Henderson, did that clear it up?
Thank you, Madam Chair. I don't think so. And maybe if I explained how I think I understand what your answer was. So someone comes into a courthouse and requests paper records. Whoever the request is being made of would go into their computer system, look at a digital file, find out where that record is being held.
Yes.
But you're saying that based on this language, if that record had been sealed, then they would say either that whatever there is no record to be held, or this is not a matter of public information, and therefore it would restrict the person requesting that file, that paper file, from being able to see it. Is that what I'm understanding?
Correct.
So you did explain it well. Thank you.
Oh, well, thank you. All right, thanks. I'm flattered.
All right. Thank you for joining us again.
Thank you.
Let's see if there are any more questions, and then maybe we can take a break and let everybody settle in for a minute. Are the committee members want to hear from anyone else here in the hearing room? I was going to ask, oh, go ahead.
Sorry, Madam Chair, the only point that I didn't hear elevated at all during this whole process is that when you know, we're talking about when a hearing would be requested to look at a particular record, that process has the state is represented, and the person whose record it is would either have to represent themselves pro se or hire an attorney. So I'm just talking, that's an additional burden within the current petition-based process that I'm not sure we've elevated. Thank you.
Thank you. I was going to ask if there's anyone from DPFR here. I think there is. Could you join us for a moment?
Good afternoon, Christina Leonard, Deputy Commissioner, DPFR.
Thank you for joining us. I just wanted to check in briefly. When you were here previously, you had concerns about syncing this with the licensing process. And I just wanted to see, does the language here address those concerns?
It does. We've worked with the senator and we appreciate the opportunity to do that. The amendment in front of you addresses the concerns that we've raised. However, I will say, and we haven't raised this with the senator, but we spoke with our colleagues at SBI about an hour ago, and there's some language that just needs to be tweaked, and we will work on that.
Okay. Do you want to characterize that, or are they technical changes, or?
I'd rather have SBI describe it.
Yeah. Okay. Well, thank you for joining us. Can we invite you up, please?
Hi, Amy McCullough from State Bureau of Identification. Basically, can I borrow your piece of paper? I didn't bring mine up, sorry. Section 515 MRSA 2265. It mentions for disseminations authorized in subsections 5, 6, and 8.
This is on page 6, committee member.
Sorry. What I have a glaring concern about is that it mentions section 8, subject to fingerprinting, which is an entity that is required by federal and state law. Anytime you mention federal, that is a blaring, screaming halt. Because when you flip back to section 5, it mentions further dissemination. Whenever you do further dissemination of federal rap sheets, the FBI Criminal Justice Legal Unit then will disapprove any fingerprinting mechanisms. So any state PFR fingerprinting mechanisms that are currently in place, they will put a halt to those if you further disseminate the federal rap sheets. So I need to communicate with CJ Liu and see what type of verbiage is needed in the statute to allow the AAG's office to view and look at the criminal histories, the federal part. State rap sheet, that is public rap sheet that they will be reviewing, so that is public. But anything that's federal, it cannot be further disseminated. Does that make sense?
Any questions? Representative Crusoe?
May I ask a different question of her as she's here?
Yes, everyone is considering what you said, I think. Go ahead.
We've had some extensive discussions on dismissals of non-convictions. And apparently, I just want to confirm with you that dismissals, non-convictions are already dismissed. And SBI would not be, if there was a background check.
Not with all of them.
That could
currently dismiss pled other. As of right now, does go out on a public rap sheet. That is part of the Criminal History Record Information Act. And that is also part of, sorry to say it, LD 1918. That is being discussed on the Criminal Justice Committee, is that they want to take that back and have that non-disseminable. to have it not be disseminated, to have that completely non-conviction, because right now it teeters on non-conviction, but we do disseminate that out because it's dismissed, pled other, but what did they plead to? Does that make sense?
Yep, so the dismissals that are currently covered are what?
Any other type of dismissals, dismiss DA other, dismiss by court, all of those are non-conviction that do not go out on a public rap sheet.
Okay, thank you.
You're welcome.
Representative Lee?
Dismiss pled other is, say, someone has domestic violence assault and regular assault charge, but they plead the simple assault. It would say domestic violence assault dismissed.
You are correct. Or like a GSA to a simple assault, dismiss pled other, GSA, simple assault for what they're actually convicted of. Correct.
Senator Talbot Ross?
Thank you, Madam Chair. So we're just talking about the difference between confidential criminal history record and non-confidential. So public
Correct.
versus, so that is current practice, but it
Correct.
doesn't cover all. Our ergo Criminal Records Review Committee recommended this to move forward.
Correct.
After several years of taking a look at it. The confidential criminal history information or record would be seen by all the entities we've already named over and
No.
over. No.
That is not what the 122265 is not confidential rap sheets. That
Right,
is
it's
not what that
non-confidential.
is.
It's non-confidential, public.
No, that is public plus the sealed. That is it.
Thank you.
You're welcome.
Representative Henderson?
Thank you, Madam Chair. So with that paper in front of you on page 2, 2402, paragraph 2,
Okay,
eligible non-convictions.
correct,
A charge that was dismissed by the court
correct.
is one that's covered. A charge that results in an acquittal,
That's non-conviction, correct,
that's non-conviction. Charge that was not formally charged by the prosecuting authority
correct,
or was declined for prosecution.
correct.
And then D, a charge that was subject to deferred disposition
And was dismissed.
and was dismissed following the successful completion of the deferred disposition.
Correct. Because
These are all
the
things.
final was dismissed, so that will not go out on a public rap sheet.
Okay, so these are all things that currently are not being
Correct.
going out on a public rap sheet. Okay, thank you.
Yes.
Are there additional questions? Representative Henderson?
Thank you, Madam Chair. One more. Someone does a background check, right? For employment or for housing, they do a background check. You say that it doesn't go out in public, like these things don't go out on public record. Does that mean that that background check won't reflect these charges? So, or do you mean that, like, if someone comes in and physically requests the information, like,
Okay,
what platform is it not going out on?
okay. So a public rap sheet
Yep.
is different than if you physically want to come in and say, I want my whole criminal history. That is different. At SBI, we would say, we want a set of your fingerprints and something in writing stating you want your own whole criminal history. We would say, we want fingerprints, we want to know that it's you, something in writing, and we will literally give you your whole criminal history, like a law enforcement rap sheet. Because you're entitled to your whole criminal history.
Right.
But we would not do that for Eli. We're not going to give give him your criminal history. He's not privy to that.
Okay. And is the information that you provide, or platform that you provided, the same as if I were an employer wanting to employ someone and decided to do a background check?
That would be a public criminal history.
That would be a public criminal history. Okay, thank you.
Correct.
Representative Caruso?
We're so glad you're here.
Oh, thanks.
So, just to clarify, if someone, a landlord is going to rent out an apartment and they do a background check, it's my understanding that when the background check comes back, it would currently, if there was a DRE crime, it would list what it was for. If it was because your light was out on your ATV or something like that, it would show what the offense was. Is that true?
Yes, yes. It shows the actual literal description, the title, the subsection, whether it is a misdemeanor or felony.
Thank you.
All right, any other questions? Committee members, should we take a break? We've been going for a while. Okay, so let's come back in just 5 or 10 minutes. All right, committee members, we're back from our break. Is there any committee discussion? Any questions? Oh, we are missing the bill sponsor. Okay. The bill.
For whoever left the doors open during the break, thank you. It's much more bearable in here.
All right, committee members, we're back to our work session. Is there any committee discussion before we have a motion? Okay, I'm not seeing any. Would anyone like to make a motion? Representative Poirier.
Thank you, Madam Chair. I'm going to move on to pass.
Just as. So we have a motion ought not to pass. And is there a second? Representative Henderson. Senator Carney.
I move to table.
All right. Is there a second? Representative Sato. And tabling motions are not debatable. So we'll do it by show of hands. We'll see where we are. All those in favor of tabling? All right, I guess we should do a roll call.
Reach across here. Thank you so very much. This on the tabling motion? Yes. Okay, thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Representative Kuhn.
Yes.
Representative Kuhn votes yes. Senator Hagan.
No.
Senator Hagan votes no. Representative Poirier.
No.
Representative Poirier votes no. Representative Sinclair.
Yes.
Representative Sinclair votes yes. Representative Pugh.
Yes.
Representative Pugh votes yes. Representative Henderson.
No.
Representative Henderson votes no. Representative O'Halloran.
Yes.
Representative O'Halloran votes yes. Senator Talbot Ross.
Yes.
Senator Talbot Ross votes yes. Representative Lee.
Yes.
Representative Lee votes yes. Representative Sato.
Yes.
Representative Sato votes yes. Representative Babin.
No.
Representative Babin votes no. Representative Caruso.
No.
Representative Caruso votes no. Representative Dana. I'll recall the absentees. Representative Dana. Representative Dana is absent. Madam Chair, I have 8 members voting in the affirmative, 5 in the negative, 1 member is absent, and that is the vote of the committee.
All right, thank you. So the motion to table carries. We'll close the work session.
Hello, committee members. Thanks for your patience. I I think that we aren't going to be able to work 2106 to the point where we can vote it today. And so with the agreement of the sponsor, I'm looking at you, Representative Sato, I would like us to not take that up this afternoon and to schedule it for a future date. Is that acceptable to you?
That is.
Okay, thank you. I do think that we have a language review on LD 2059 that we need to complete from yesterday, but we're not ready to take it up now. We need a couple more minutes to work on it, maybe about 10 minutes. And so let's be at ease for 10 minutes, so until 3:40, and then we'll be back here at that point and decide where we're going from there. So we'll see everybody at 3:40. Thank you.
I was doing the report tonight.
Committee members, thank you for your patience. We are going to take up 2106 at a later date. I think I announced that earlier. But we are going to continue our language review on 2059. And I think we all have that in front of us. Okay, so we are on LD 2059. This is a language review, and I think we started this yesterday, Janet. Is that, had we completed the review of the document itself?
Yes, so you have a copy of my version, so everyone was okay with the language. So that's what I had written, but then there was a discussion of possibly reconsidering, but you decided to think about it overnight. So the language was fine, just whether that would lead to further discussions was not resolved.
Okay, thank you. And we had tabled it, and we are taking it up now, and I'll recognize Representative Kuhn.
Having voted on the prevailing side, I'd like to move for reconsideration.
Thank you. Is there a second? Seconded by Representative Lee. And is there any discussion on reconsideration? No. Would anybody wish to make a motion
Did you
to
vote?
frame our discussion?
Did you vote on?
Oh, we have to vote on the reconsideration. I'm sorry. Thank you for the reminder. All those in favor of reconsideration, please raise your hands. So we're going to ask, Suki, could you please do a roll call vote on that? Yeah, yes, go ahead. Thank you.
Senator Carney?
Yes.
Senator Carney votes yes. Representative Kuhn?
Yes.
Representative Kuhn votes yes. Senator Hagan?
No.
Senator Hagan votes no. Representative Poirier?
No.
Representative Poirier votes no. Representative Sinclair?
Yes.
Representative Sinclair votes yes. Representative Pugh?
Yes.
Representative Pugh votes yes. Representative Henderson?
No.
Representative Henderson votes no. Representative O'Halloran?
Yes.
Representative O'Halloran votes yes. Senator Talbot Ross?
Yes.
Senator Talbot Ross votes yes. Representative Lee?
Yes.
Representative Lee votes yes. Representative Sato?
Yes.
Representative Sato votes yes. Representative Babin?
Yes.
Representative Babin votes yes. Representative Caruso? Representative Dana? I'll recall the absentees. Representative Caruso? Representative Caruso is absent. Representative Dana? Representative Dana is absent. Madam Chair, I have 9 members voting in the affirmative, 3 members voting in the negative, 2 members are absent, and that is the vote of the committee.
Thank you very much. And so we are reconsidering the motion and, reconsidering the vote, and Representative Kuhn?
Thank you. I would move ought to pass as amended, and it's the majority report on the pink paper.
Thank you. And is there a second? Second by Representative Sato. And is there any discussion on the motion? Okay, then is the committee ready for a vote? It appears that we are. Clerk Panet, could you please call the roll?
Well, absolutely. Thank you, Madam Chair. Senator Carney?
Yes.
Senator Carney votes yes. Representative Kuhn?
Yes.
Representative Kuhn votes yes. Senator Hagan?
Yes.
Senator Hagan votes yes. Representative Poirier?
Did I screw it up? Can I go back or do I have to wait?
The motion was for the majority report.
Oh, the majority, I made a mistake, so what do I do?
I'll recall Senator Hagan.
Could you please recall Senator Hagan?
I'd
Thank
be
you.
more than happy to. Senator Hagan?
No.
Senator Hagan
Thank you.
votes no. Representative Poirier?
No.
Representative Poirier votes no. Representative Sinclair?
Yes.
Representative Sinclair votes yes. Representative Pugh?
Yes.
Representative Pugh votes yes. Representative Henderson?
No.
Representative Henderson votes no. Representative O'Halloran?
Yes.
Representative O'Halloran votes yes. Senator Talbot Ross?
Yes.
Senator Talbot Ross votes yes. Representative Lee?
Yes.
Representative Lee votes yes. Representative Sato.
Yes.
Representative Sato votes yes. Representative Babin.
Yes.
Representative Babin votes yes. Representative Caruso. Representative Dana. I will recall the absentees. Representative Caruso. Representative Caruso is absent. Representative Dana. Representative Dana is absent. Madam Chair, I have 9 members voting in the affirmative, 3 members voting in the negative, 2 members are absent, and that is the vote of the committee.
Thank you very much. And committee, for those who voted against the motion, could you please let us know your report?
It ought to pass as amended with the minority report as outlined in the language review.
Thank you. And is that yours as well, Senator Hagan and Representative Poirier? Okay, thank you. Before we close this reconsideration, I wanted to let committee members know that tomorrow morning, Soupy will have the signature document ready for us to sign to verify our votes on this bill. And if you could, Janet?
She will, as long as she has all the votes,
Okay.
which we are missing 2 people.
Missing 2 votes.
Because
Okay.
it can't be printed until all the votes are ready.
Thank you for clarifying that. So if you could please check in with either Senator Hagan or myself or Representative Poirier or Representative Kuhn. We will let you know as soon as all the votes have been registered, such that we can all sign the vote sheet so that we can expedite getting this legislation out. Thank you, everyone. And Janet, thank you for clarifying the process. Anything further, committee members? Okay, so we'll close the work session on 2059. And at this point, does anyone have a motion to adjourn? Thank you, Representative Poirier, seconded. All those in favor? We are adjourned. Thank you, everyone.